In fact, with the due humility, my lords, I am humbly submit, my lords, I have gone through that. This is pending. On Annex 3 is the impugned order. I think it is an appealable order, my lords, cannot ignore it. Section 9, yes.
So you withdraw and go and appeal then. The impugned order by the OSA collector is an appealable one. Accordingly, counsel for the petitioner seeks leave to withdraw the present petition to prefer an appeal before the concerned appellate authority against the said order in accordance with law. If such appeal is filed not later than 2nd May 2022, accompanied by an application for condonation of delay, citing the tendency of the present petition as the reason for the delay, it will be considered on merits by the appellate authority. There is a status quo order here? No.
3490.
34.
Minutes.
No. Which is the date of the interim order? I can't see the interim order.
Interim order, but there is no interim order. Interim order is.
All right. The appellate authority should endeavor to dispose of the appeal within a period of 4 months thereafter. The petitioner will appear before the appellate. No, that's it. The petition is disposed of in the above terms.
Weekly list all matter item number 2.
May make a mention. The mention hour is, I'm conscious because I attempted in the concerned court, Miller. I have an urgent case. It's a review petition. Because of this, without being heard, the case is disposed of, being covered by another judgment. But that judgment is not covering me, as a result of which I will be reverted immediately.
No, but what is it? Single judge division bench? What is it?
No, it's not single it's division bench, Miller.
Who's the division bench?
My case is only to be listed, Miller.
No, who's the division bench?
It's my Lord Justice B.R. Sadingi and Erath, Miller. I made a mention, but they will not.
No, but there's no, can't give it to you before 8th April.
I'm conscious of this because there existed, my time existed there. That's why I came in.
No. 8th April is the only date that can be given.
8th April. If it is not today.
It's all right. It will all be subject to the outcome, sir. Whatever will happen will be subject to the outcome. That's all. 8th April.
But,
right.
Weekly list all matter item number 2.
My lords, OGS number 241 of 2001 has already been disposed of by this honorable court, and that has been reported in 14 VST 509. The question was answered. Question was whether in the case of
this is a wrong list you are mentioned, not your case.
This is the weekly daily, sir. We are in OJC number 2703.
Sorry.
None appears dismissed or non-passed.
Item number 2, I am for the opposite party, my lord.
All right.
Weekly list all matter item number 3.
I am appearing for the petitioner, my lord, in this case, through virtual mode. In this case, no instruction.
No instructions. So all 3 gone.
Weekly list item number 4.
My lords, OGS number 12241 of 2001 that has been disposed of by this.
So which matter are you appearing in, sir?
All the matters, my lords.
Which all matters?
That is Jagannath Enterprise and DCS Guruvallu.
What is all this? He just now appeared and he said no instructions.
Item 4.
All confusion is.
Perhaps my lord.
We are in the weekly daily list, sir.
My lords, I am appearing for item number 3, my lords.
Okay.
OGS number 12241 of 2001 that has been disposed of by this honorable court, which was reported in 14 VST 509. The question was whether in the case of purchase tax paid goods, the royalty paid to the government for procurement of tamarind from the lease out area can be treated as purchase turnover of the tamarind for the purpose of payment of tax under the OST Act. The Honorable High Court held that, while deciding the law, has held that petitioner has rightly treated the royalty paid to the government for procurement of tamarind from the lease out area as purchase turnover of the tamarind for the purpose of payment of tax under the OST Act. My lords, that first item, 14668.
It's only 4668, sir.
466, sorry, my lord. 4668. My lord, matters become infructuous because basing on this order of the Honorable High Court, the tribunal has granted the relief.
All right. 4668, he says, counsel petitioner states that the tribunal has already granted the petitioner relief and the petitioner has become infructuous. It is
My lord,
disposed of.
it has
as
become
such.
infructuous, my lord. With regard to 4669, that has also become infructuous because the tribunal has already granted the relief.
Same order in that. Then,
My lord, in the case of 6213 of 2004, my lord, same order may kindly be passed as the Honorable Court has earlier directed that is reported in 14 BST 509.
you show us that judgment or something, sir.
My lord.
In fact, my lord, if your lordship would see the order dated 17th of August 2004 passed in this writ application. The matter has been referred to the full bench, and this matter was also tagged to that full bench judgment. my lord.
My lord, already the full bench was a dissented
Yes.
matter. Thereafter, the matter was listed before the division bench, and this is the judgment I have given.
All right.
Decision of the division bench.
Okay, 2008 judgment. This is. This petition is disposed of in terms of the judgment dated. Judgment in Messrs. DCH Guruvalu Son and Company was the sales tax officer. 2008 1 OLR 18. In the same terms. That's
My lord.
Weekly list item number 4.
Item number 4, item is infructuous due to
Or-
inflection of time.
all right. Due to passage of time, the petition has been rendered
I may be
infructuous.
pardoned to make a mention. Item number 27, brief has been transferred from our office.
All right. 27, you see, counsel for the petitioner states that the papers have been taken away. The petition is dismissed for non-prosecution. Right.
Weekly list item number 5.
is for the opposite party. my lord.
All right.
27 is for the opposite party.
All right.
Weekly list item number 5.
None appears dismissed for non-prosecution.
Weekly list item number 6.
None appears dismissed for non-prosecution.
Weekly list item number 7.
May I please, your lordship?
Yes. What's the tax effect, Mr. Padi?
Yes, my lord.
No, tax effect.
The tax effect is 1,15,000.
All right.
My lord,
Requisites.
is in fact, here the question of law my lord, has not been framed.
Not framed.
Here, my lord, the question is whether the transaction in question, whether it will be an interstate sale or intrastate sale, my lord. The tribunal at, my lord, may turn to page 25. This is the finding of the tribunal.
Applying the test.
My lord, applying the test laid down in the aforesaid decision to the case in hand, it is seen that the revenue has not been able to establish that the transaction in question is an interstate sale. Admittedly, there is no written agreement to sell pursuant to which the good can be said to have moved from Orissa to outside the state. Similarly, no satisfactory material has been placed, I believe it was, to show that the movement of the goods occasioned pursuant to any contract, either express or implied. Merely on the finding that the raw materials purchased by the appellant have been sold and transported in the same truck to the parties outside the state, no definite conclusion can be drawn
This
that
is
there.
factual, sir. This entire thing is factual.
Yes, my lord. I've gone through the assessment order. That's at page 13, my lord. These are the two grounds on which it has been held to be an interstate sale. Page 13 is the assessment order. Paragraph A and B. So A says that the same thing, since those goods have been transported on the same day.
That's okay. You have
Yes,
to have some supporting document for that, sir.
No, my lord, no, there is no express agreement.
All right. The state is filed this revision petition, urging the following question of law. Just take from page 6, para 10. Paragraph. On a perusal of the impugned order dated 9th December 1994 passed by the full bench of the Orissa Sales Tax Tribunal, it is seen that the decision on the above issue by the tribunal turned purely on facts. So it was noticed that no satisfactory material has been produced by the state to show that the movement of the goods was occasioned as a result of any express or implied contract. So merely because the goods had been transported to places outside the state did not lead to an inference of interstate sale, particularly since, open quotation, not a single way bill has been produced on behalf of the state to show that the appellant had dispatched the goods as a consignor to outside state parties, unquote. No, in the considered view of the court, the question of law sought to be urged does not arise in the facts and circumstances of the case. The revision is accordingly dismissed.
Weekly list item number 8.
8 minutes. Tax effect is 46,000.
Not much.
And all ancestral brief, my lords. And I have to, the successor is only to.
The tax effect being not substantial.
Questions may be left open.
Yeah, the questions are left open for decision in some other appropriate case. The petition is disposed of.
Weekly list item number 9.
9, my lord, tax effect is 3,600.
The tax effect being totally insignificant. The court leaves the questions of law open for decision in some other case. The petition is disposed of.
Weekly list item number 10.
My lord, no instruction item.
No instructions disposed of.
Weekly list item number 11.
11 is also, my lords,
23,000.
23,000. And this
Same
is
order.
also ancestral brief.
Same as 8. Yeah. All right.
Weekly list item number 12.
Questions may be left open.
Yes. Same as.
Oblige.
12, my lord, it's item rupees 3,654.
Same order.
Weekly list item number 13.
None appears dismissal, not resolution.
Weekly list item number 14.
14 years, my lord, it's 4,600.
Same order.
Weekly list item number 15.
No instruction, my lord. I am in the
Yeah.
VC, no
All
instruction.
right.
Lord.
I am for
If it is the cause of action survived, then
All right.
oblige, man.
Weekly list item number 16.
Item number 16, my lord, herein in this writ application, I have prayed to refer the dispute to the civil court under section 30 of the Land Acquisition Act. The matter pertains to acquisition of a piece of land regarding which there is a dispute between the parties regarding right title, interest and ownership, and as to who is entitled to compensation. The facts leading to this writ application is that, my lord, the land which were acquired under the Land Acquisition Act was originally recorded in the name of my grandfather as Jagiri land. In lieu, he was possessing the land.
Just second, with kind permission, all the submission may not be necessary. I have given that judgment of your lordship, my lord. The lordship have relegated matter back to the unruled single judge, and the result of this matter will be certainly depending upon that decision. So all the will not be.
Oh, it's connected with this.
It was connected. It came along with that. That your lordship remanded matter back to this unruled single judge.
Okay.
So result will be depending upon that one.
Okay. So this is also a single judge matter then?
No. This is
No,
a
not
single
a single
matter.
judge matter.
Either this may be disposed of directing that this will abide by the order passed by the honorable single judge, or this may be kept in whatever. This may be kept pending till that is disposed of. Either way,
The writ application number is
I have given the judgment.
The status was already ordered in that.
Yes, Lord. Lordship has remanded matter back to the honorable single judge.
All right. By an order dated 3rd March 2022 in Writ Appeal 376 of 2010, bracket Raj Kishore Bagh versus Om Prakash Agarwal, writ petition civil 9885/2009, which is connected with the present petition, was remanded to the file of the learned single judge for a fresh decision. And pending the said decision, the parties were directed to maintain status quo.
Correct.
Paragraph. Since both petitions are connected, the present petition is adjourned, sine die, awaiting the decision of the learned single judge in writ petition civil 9885/2009. Full stop. Once the decision is available, it will be open to the parties to mention the present writ petition for listing. All right.
Weekly list item number 17.
17. I am challenging Annexure 3, the order for non-compliance of the principle of natural justice. My lord, but in the meantime, he was 78 years old when the matter was filed.
Then is he
But in
there?
the meantime, I am unable to get the information whether he is dead or alive.
What is it?
Lordship, may
This is additional Tahsildar. That order must be appealable, sir.
my lord,
Is it an appealable order?
My lord.
it is an appealable order.
Then you withdraw and go and appeal. If meanwhile he's
Your
died, his
Lordship,
LRs will file it.
Yes, your lordship, may with that
All right.
observation, your lordship, may discuss.
Considering that the impugned order of the additional Tahsildar dated 20th May 2002 in WL case number 763 of 70 is an appealable one. Concept of the petitioner is permitted to withdraw the present petition to approach the appellate authority in accordance with law. Concept the petitioner states that she is not aware if the petitioner, who was 78 years at the time of filing of the present petition, is still alive. Full stop. The permission above granted is also available to the legal representatives of the petitioner in such event. Full stop. If the appeal is filed not later than 2nd May 2022, accompanied by an application for continuation of delay, citing the pendency of the present petition as the reason for the delay, it will be considered on merits by the appellate court. The status quo passed by this order passed by this court on 6th August 2012 will continue till such time the appellate authority passes an appropriate order on an application for interim relief to be filed along with the appeal.
One of the direction was to delete the name of the petitioner for correction of ROR matter. It has already been recorded probably, my lord. Government khata.
Sorry, just come again.
My lord, I'm saying that the impugned order, my lord, says, my lord, for correction of ROR. And this order was passed in 2002, challenged in 2011, my lord.
Yes. I know in 2012 we passed the status quo order.
Yes, ma'am.
The petition is disposed of in the above terms. All right.
Oblige, my lordship, urgent copy of your lordship.
Yes, yes. All right.
Weekly list item number 18.
None of this Mr. Nabas.
Weekly list item number 19.
Under item number 19, there are two matters. In the second matter, I am appearing for the petitioner. So far as I know, the counsel for the petitioner in the first case is no more.
So first case is abated.
Counsel is no more.
All right. First case, none appears. This was a non-prosecution. Second case.
Second case is both the cases arise out of one award. The petitioner was an employee of a cooperative society. He was recruited in 1968. In 1/10/1975, he was due to misappropriation of society money, he was placed under suspension in 1968. My lord, 14/9.
So the worker himself has died, sir.
My lord,
the worker himself has died. The workman is dead now.
Legal representatives have been substituted.
What do you want to chase them for? What are you chasing them for?
My lord, the tribunal, labor court held the reference not maintainable and also held that the petitioner is not entitled to anything. Nevertheless, the PO held that the termination was not legal and justified.
So what is the relief granted? What is the relief granted to the workman, sir?
No, we only the management has come only to quash that part of the award, my lord.
Sir, he's dead, then what are you challenging?
My lord, my password. My duty is to place the material.
All right, the management has filed the present petition challenging a labor court award which found the termination of the workman services to be illegal and ordered his reinstatement.
No reinstatement, my lord. No relief can be granted.
No.
Labor court has
Illegal, but did not grant any relief. The court is unable to understand how the impugned order is prejudicial to the management, particularly since the workman himself is no more. The petition is accordingly dismissed.
Weekly list item number 20.
May I please, my lord? And the petitioner is was the workman and working under opposite number 3, my lord. And the law and PO Sambalpur passed the award declining the petitioner's relief, my lord. And the fact is that the petitioner was working under opposite number 3, advertisement under annexer 2, my lord, page 31, and thereafter he was appointed, and the labor court held that the petitioner was working under one orange security, but that is not true. He was working under opposite number 3, my lord. Page 33 is the appointment letter, my lord, issued by the opposite number 3, the Central Electrical Division, my lord.
What was the term of reference? That's not clear, sir. What was the term of reference?
My lord.
What was the term of reference before the labor court?
Annexure 1 is the award passed by the PO labor court, my lord. Turn to page 29 award. The workman is not entitled to get any relief in this case. The reference is so and so. My lord, from the top, my lord, in view of the facts and circumstances, it can be said that the second party was working under Orange Security Private Limited. He was also terminated by the said agency, but the agency was there no more, my lord. He was appointed by the opposite one number 3, my lord.
And what is that to show, sir? This is all factual, correct?
Yes, ma'am.
What evidence did you lead to show that you were employed by the opposite party number 2?
Deposition of petitioner, my lord. I was attached to SESCO Kamakhinagar section as meter reader and work so and so from 26/6/2002 to 14/9/2004. The chief executive officer SESCO published an advertisement in Delhi Samaj 29/4/2002, and then I applied to the appropriate authority and appeared before an interview and was recruited as a security person. I was placed under Kamakhinagar subdivision exit 1 is that advertisement. Annexure 2, my lord, in this writ application is the call letter annexure 3, so and so. Then I was selected as a meter reader exhibit 4 is the letter exhibit 5 marked with the objection. It is Xerox copy of the attendance, so and so. So 14th September 2004 and 15th September the authority did not allow me to work. He is categorical stated I am working under opposite number 3, my lord.
Mere stating is not proof, sir. Come to page 26.
Yes, ma'am.
Para 12 of the award.
Yes, ma'am.
Please read it, sir.
The workman raised the point about the change of his service.
Sir, para 12.
Yes, yes, ma'am. The second party workman relied exhibit 1 to Exhibit 4, he admitted that he has not received any appointment order relating to advertisement number 1 and 2. But fact is,
Please
appointment he
read
has
on, sir. Kindly read on.
order relating to advertisement number 1 and Exhibit 2. There is nothing in Exhibit 3 and 4 regarding terms and condition of any appointment against any post. So as for the reported decision 1982 LLG 1067 SC in selection pursuant to advertisement doesn't give any right to a workman for appointment as per Exhibit A. The letter number so and so SESCO issued to the Orange Security Private Limited for engagement of 300 numbers of ex-servicemen for dehooking and a disconnection squad. Exhibit C is the movement order. Exhibit E, G, and H disclose that the workman, by putting his signature, has drawn his salary in the month June, July, and August, respectively. Exhibit J is the release order 19/2004 by MS Orange Security Private Limited. In view of such facts and circumstances, it is evident that the second party is a workman under MS Orange Security Private Limited, and he was getting his salary from Orange Security Private Limited. The second party has not filed any document relating to his salary as he was drawn from the management. The management relied on the reported decision so and so in absence of a receipt of proof of salary of wages or a record of appointment. Filing of affidavit is not sufficient proof that the workman had worked under the management.
So what is your answer to this?
Simple, my answer is that, my lord, he was working under opposite number 3.
Simply saying that. What is your answer meaning? What are these documents showing? The documents are showing you are employed by that agency or in securities.
Only my document is that Annex 3 page 33. This is the appointment letter given by the opposite number 3, my lord. Engagement of a security personnel to form dehooking squad under different subdivision. Specifically, this office letter and so and so, the following security personnel are placed under your subdivision.
Sir. These are not employed by, they're placed. You are actually provided by the agency and you are placed for duties in different offices. All right. You say the workman has filed the present petition challenging the award dated 20th October 2010 of the Labour Code Sambalpur. In this case, ID case number 1 of 2006. Stop. The dispute referred to the Labour Code for decision reads as under, take from page 14, the question, paragraph. The Labour Code answered the above question in the negative. No, is in the affirmative by holding that the workman was never engaged by the executive engineer (electrical) SESU, but was in fact working for Messrs. Orange Securitas Private Limited. To stop in para 12 of the award, there is a detailed discussion of the documents which showed that the workman was never employed by the executive engineer, SESU. Paragraph. Counsel for the workman referred to a letter dated 26 June 2002 issued by the EE, Denkana Electrical Division of SESU, addressed to the subdivisional officer, Kamakya Nagar, informing him of the names of persons who had been placed in the subdivision, open quotation, to form dehooking squad, unquote. The said letter by no means suggests that the workman was directly engaged by the EE. On the other hand, it merely states that he was being placed as part of the dehooking squad for that subdivision. Paragraph. With there being no material placed on record to enable the court to come to a contrary conclusion, the court sees no reason to interfere with the impugned award of the Labour Court. The petition is accordingly dismissed.
My lord, I am for the opposite party number 3. My name may be recorded.
All right.
Weekly list item 21.
Item 21, my lord. My lord, may I pray it to be taken up after recess? I will attend the physical hearing, my lord.
All right.
My lord.
Weekly list item 22. Item number 22.
Nana Pistis was not also.
Weekly list item 23.
Page follow.
23.
Petitioner is challenging the order passed by the Tahsildar as well as the sub-collector by Annex 1 and 2, my lord. Petitioner is a purchaser of a land from original vendor Nursingha Sahu, my lord. Nursingha Sahu has purchased the said land. Nursingha Sahu father has purchased the said land in the year 1940, my lord. Thereafter, the present petitioner's father has purchased the land from the Nursingha Sahu in the year 1995, my lord. After 2000 circular issued by the government, the cut-off date was fixed on cut-off date was fixed on 25/8/83. If any person has not applied within 1 year from the order government circular, they will not their rent will not be fixed, my lord. So within 1 year, the petitioner father has applied for the fixation of rent, and the original vendor also filed a case to fix the rent. In the same plot, the original vendor rent was fixed and the petitioner pair was rejected on the ground he has purchased the land after the cut-off date, my lord. That is my grievance.
No, what is your grievance? That's the conclusion drawn by the.
My lord, that property has earlier purchased by the vendor of the petitioner, my lord, in the year 1940, my lord.
No, but you purchased it after the cut-off date.
But the land is same, my lord.
Of course, the land is same, sir.
If the vendor property was rent was fixed, the petitioner is debarred to get that benefit, my lord.
Mr. Mohanty, I'm not able to understand what he's arguing, so you tell us.
He is saying that his vendor's case was considered, but on the same footing, his case was not considered only on the point that he purchased the land after the cut-off date. And that is a technical issue which the learned courts below have properly dealt with, and he is not entitled to the relief. That is the only.
What is the
and he has to meet that point that how.
Cut-off date change? What is the change brought up at the cut-off date?
Cut-off date.
Cut-off date is
No, what is the change? Cut-off date must be under the law, correct?
Yes.
Under
the
what
government
law?
guideline by Annex 3.
What was the cut-off?
Right, Annex 3, he has given the document.
Cut-off date is 25/8/1983, man.
I have no idea, sir. Simply saying cut-off
No.
for what?
You place the document.
Annex 3.
Don't kuhantu.
The government has passed its guideline by Annex 3. This.
Page 16. Circular.
So the land already stands vested in the government, correct?
Yes, ma'am.
Because it stands vested in the government, no rent can be fixed.
So within a particular date, if somebody filed a petition for fixation of fair and equitable rent, that will be considered. That is the circular. And he came late.
Yes, purchased later. All right. What is that to decide?
My lord, within 1 year I have applied, my lord. But though I have purchased after the cut-off date, so that is the 1995.
So how is your case made out then? Admittedly, you purchased it after the cut-off date, sir.
Yes, ma'am.
My case is though vendor case has been considered. So my
Your vendor purchased it earlier, obviously.
well, from that land I have purchased, my lord.
Correct, but your purchase is after the cutoff date, sir.
Sir, your lordship may kindly see page 18. Page 18. Just before last para B.
Bottom.
No. Allow rent settlement in favor of the persons if it is found through local inquiry that the persons who service tenure holders under the ex ruler of their family members and are continuing to possess the land either as successor in interest or on the basis of valid transport deeds executed prior to 25/8/83.
So his vendor purchased it prior to that.
Yes.
You say the grievance of the petitioner is that while the petitioner's vendor has been, in the case of the petitioner's vendor, the rent has been fixed for the land in question by the government, it is not in the case of the petitioner. Paragraph. In terms of the circular dated 6/12/2000, rent could be fixed if the purchase took place prior to 25th August 1983. Stop. Admittedly, the petitioner's purchase was after that date, and therefore he could not take advantage of the, and therefore he could not obtain the remedy of fixation of rent as per the circular dated 6/12/2000. Stop. The said circular itself is not under challenge before this court. Stop. In the circumstances, there's no error to be found in the order dated 18/11/2002 passed by the Tahsildar Sukinda, Jashpur Road, in Bay Bandobast, case number 868 of 2001, or the order dated 5th October 2009 passed by the Sub-Collector Jashpur in miscellaneous appeal case number 2 of 2007. The petition is accordingly dismissed.
List item number 24.
No instruction memo is taken on record.
List item 25.
My lord, I'm petitioner, but the brief is transferred from me. So
All
my
right.
name may be
Counsel, the
deleted.
petitioner states that the brief has been transferred from him. Dismissal not prosecution.
Wiki list item 26.
I am for the opposite party.
26. Milord, 26, Milord, I am for the opposite party, Milord.
All right. None appeals to the petitioner. Dismissal not prosecution.
Milord, my name may be indicated as Das.
Sure.
Wiki list item 27.
Milord, I am for the opposite party number 2.
All right. None appeals. Dismissal not prosecution.
Milord, 27 may be taken up after this, Milord. A physical hearing, I will attend, Milord.
All right.
My lord.
Wiki list item 28.
None appeals. Dismissal not prosecution.
Wiki list item number 29.
I am appearing for opposite party number 3.
All right. None appeals. Dismissal not prosecution.
Instructions, my lord. I am for the petitioner, my lord.
All right. Petition is rendered infractions disposed of as such.
Wiki list item number 30.
No instruction.
No instruction disposed of.
Wiki list item 31.
None appeals. Dismissal not prosecution.
Wiki list item 32.
None appeals. Dismissal not prosecution.
Wiki list item number 33.
This is a single based assignment. Order
Once
of
the petitioner
information
says
commission
that
is
the brief has
under
been taken away from him. Dismissal not prosecution.
But I am appearing for State Information Commission.
This is a single bench case. Order under challenge the order of the State Information Commission.
All right. Which is this item?
33.
33.
The Lordship can also hear this matter, no problem. It is an old matter, that's why Lordship's assignment, no problem. I am appearing for State Information Commission, my lord.
But he has not made the opposite party, not serve opposite party number 2.
Did we notice that? So fresh notice may.
No, not at this stage, sir.
But what happened, he is the PIO, he has not supplied information in a time, that is why 5,000 cost.
The PIO is the lecturer of an aided educational institution.
Maybe he has already retired and he has a responsibility to give the information, but in fact, he has not given the information. Lordship, kindly see paragraph 3 of the judgment, page 25.
I am for the petitioner. The PIO is a lecturer of aided educational institution. The one lecturer of that college has for some information. The application of the information is defective to the effect that he has deposited the treasury challan. The treasury challan is not encashed by the college of a private college. That part he has not enclosed his identity card.
Understand? He's for the petitioner.
Though the several correspondences made to the
5,000 penalty, why should we interfere, sir?
5,000, there is no fault on part of
This
the
is,
PIO.
Lordship, kindly see paragraph 3 of the judgment, page 25.
There is no fault on the part of the PIO. Though several letters issued to the applicant, she didn't turn up. She didn't turn up. Even did not deposited the required fees for supply of the information and filed the second appeal. In second appeal, though all the facts have been intimated, has been given, placed before the State Information Commissioner without considering the difficulties and non-cooperation of the applicant, the State Information Commission imposed penalty of 5,000 on the petitioner.
It should have been 25,000, my lord, in view of section 20, but 5,000 lenient view commissioner has taken, my lord.
But if a lordship gone through the material suburban record, he has not at a fault. The application itself is defective and the PIO has also supplied all the information without any fees. Hearing from his own, he supplied all the documents. Though a letter was issued to the petitioner to deposit, kindly come annexure 6, page 12, annexure 4. The petitioner wrote letter to deposit rupees 656 towards the cost. That was also not deposited. But by order on the compulsion, he has supplied all the information, the cost of the documents, so also the postage. So I pray that the imposition of penalty petitioner may be exonerated from that, because he has no fault at all.
What is this 5,000 is nothing, sir.
Nothing for a lecturer of a
and he's
that apart, so some lenient view may be taken. The lordship may taken a lenient view so far as penalty is concerned.
All right, considering that the petitioner is now 69 years old and is only drawing a pension, and considering that the stay of the impugn order of the State Information Commission has been continuing since 2nd December 2011, the court modifies the penalty amount from rupees 5,000 to rupees 1,000. The amount shall now be paid within 2 weeks. The petition is disposed of.
Weekly list item 34.
None appears dismissal in opposition.
Weekly list item number 35.
I may be part. In that 33, my name may be recorded on behalf of the Information Commission.
All right, all right.
Grateful, man. I'm so sorry.
Item 35.
None appears dismissal in opposition.
Weekly list item 36.
My lord, may I please your lordship? Your lordship, may kindly pardon me. Yesterday evening, I received the brief. I have made my appearance today. May I only pray 1 week breather to assist your lordship? I couldn't, my lord, get ready. Your lordship may pardon me. I only humbly pray, my lord, 1 week time may be granted. There is some substance of, it is not instructors. Otherwise, I would have said, my lord, I only pray 1 week time. If your lordship fixes it to next week, I can assist your lordship.
All right. At the counsel, request of counsel, Mr. S.K. Mishra, counsel for the petitioner.
I have appeared today, man. I filed my power.
Just on 12th April.
Much obliged to your lordship. Deeply obliged.
Weekly list item 37.
Yes, my lord. My lord, in this case, my lord's order was to issue notice. Notice was issued on 29/10/2011. Nobody has appeared on behalf of the opposite party, my lord. My lord, page 14.
Service complete.
Relevant portion of the award is at page 14, my lord.
No, have you served opposite party number 2?
Opposite party number 2, my lord.
We served them. Have they been served, sir?
It has been served. Requisite has been filed on 29th October 2011. my lord.
Serving, sir, serving. Have they entered appearance? Has anyone appeared on their behalf? What's the thing? After due service? Okay. Yes, sir. What's the award say?
Yes, my lord. It is expert award, my lord. My lord, page 14. Copy of the notice dated 6/9/94 discloses that the workman was asked to face interview for the post of Chowkidar. Exhibit 4 is the copy of the experience certificate, which showed that he was working under the management since the year 1980 as a casual worker. A perusal of the evidence of the workman and the document filed and approved by him in the proceeding shows that he was under the employment of the management for a period more than 15 years.
Come to para 5, sir.
Para 5, my lord.
Of the award.
Yes, my lord. The management though filed written statement but did not choose to contest the case, for which it was set expert.
So what did you do, sir, for that? What is the reason?
I do not know, my lord.
Then what remains the case then?
He has not been reinstated. It is in the meantime 13 years has passed. No back wages was granted by the labor court also, only reinstatement. I have filed this writ application praying that the full back wages may be given to me. Notice has been sufficient, nobody appears.
Are they still there, sir? This is some horticulturist Sapta Sajaya farm. Is it still there?
Yes, it is still there, madam. This is under government of horticulture, madam.
No. So did you go for execution of this award?
My lord.
The operative portion come to page 14, sir.
My lord. In view of the finding as aforesaid, the workman is held entitled to reinstatement in service. He is, however, not entitled to any back wages.
No. So what did you do? Did you go back and service?
He has not, after service of my award to the management, they have not taken me into service.
But there are provisions, sir. Have you invoked those provisions?
My lord, that would take time, but here I have challenged. But I have
What
challenged.
is taking time? We are 2022, 11 years. This has not taken time.
My lord, I have here before my lord for back wages, my lord.
Sir, but did you get back in service? Where's the question of back wages? You've not started working there.
Back
You
wages
should have got back. You should have started working there. Then we can talk of back wages.
back wages for the past period, my lord. The period,
Unless you go back and join and start working, where is the question, sir?
my lord, after serving of the copy of the award, if they do not take back.
What is the steps to be taken? This is not a Lok Adalat, sir. If a labor court award has to be executed, what should you do?
My lord, that is one part regarding.
You're not one part. You tell us what is that part.
That is 29, my lord. Section 29.
No. 33.
Yes, my lord.
Anyway, have you invoked or you've not invoked?
No, my lord, I have not invoked. It is their duty because otherwise they have to.
Who's that their duty? I think you don't understand then. What is this their duty? Tomorrow you'll have a money decree. Your client, you'll say it is their duty to pay. We are not to do anything. Is that what you will tell your client?
My lord, money decree is not here.
It's not the same thing as this. Here your workman is asked to be put back in service. You don't want to do anything. You are the workman lawyer, correct? The workman has got an award in his favor, but reinstatement.
Yes, my lord.
Now, what have you told your client? No need. Management will call you one day. That day you go to work.
No, we have sent that in the registered post.
That is enough. Nothing to do. 11 years. Send by registered post and relax for 11 years. What is this, sir? What is this kind of an attitude? Are you not supposed to help your client?
Since nobody appears on behalf of the, may I serve a personal notice?
You're not answering the questions we ask you. You're saying your own thing.
No, my lord. Once they are not appearing.
See, you did not even bother to get the petition listed, sir. It came up once for hearing on into 21/10/2011.
My lord.
27/10/2011.
It is 28th January 2012.
Whatever. You never bothered to have this listed also, sir.
Thereafter not listed, my lord.
You're not worried about your client at all, sir. That's the problem. You did not appear when it was listed on 7th March. Your client is not interested in going back to work.
Yes, he is interested, my lord.
Then what have you done?
My lord, with that observation, may be disposed of, directing them to reinstate that.
Despite the petitioner workman being reinstated in service by means of the impugned award dated 19/2/2009, steps have not been taken to enforce that award by him through his lawyer. So there's no reasonable explanation offered by the counsel of the petitioner for this lapse. Having perused the impugned award, the court is not satisfied that any case has been made out to interfere with the award only because it is not awarded back wages to the petitioner. No ground is made out in that regard. The petition is disposed of.
My lord, as regard reinstatement, my lord.
What should we direct, sir? The law is already there. What should we direct?
My lord, this is because I have come here for back wages, my lord. My lord wants to not to interfere. But as regard back wages, it is unchallenged. Na reinstatement, it is unchallenged, my lord.
All right.
List item number 38.
But I am 38, I am appearing.
Please tell us. The impugned order is at Annexure 7. But the lease has been cancelled after 24 years. Even without issuing notice to me, Lord, I have given a date chart. Your Lordship can see for your Lordship's convenient appreciation. What is the point involved in this case, my Lord?
What are you are the original lessee?
No, I am the purchaser from the original lessee.
So the same thing
Yes.
then.
Then no notice was given
Petitioner
to
who is
me.
the purchaser from the original lessee questions the impugned award order dated 30th June 1996 passed by the Additional District Magistrate Bhubaneswar in RC case number 630 of 1998. On the short ground that the said order which cancels the lease in favor of his vendor was passed without giving the petitioner a hearing. Paragraph on the above short ground which has not been contested by filing any reply, the impugned order is set aside and revision case number 630 of 1998 is restored to the file of ADM Bhubaneswar. The petitioner will appear before the ADM Bhubaneswar
Your Lordship
on 25th April 2022 along with a downloaded copy of this order. The ADM Bhubaneswar will, after hearing the petitioner and any other party who may have any interest in the land in question, pass a reasoned order afresh within a period of 4 months thereafter. Till such time, the status quo order passed by this court on
The status quo order on 1/11/2020.
Sorry, 1st December 2011 will continue. The petition is disposed of.
Lord, your Lordship, kindly observe one thing, Lord, because the entire initiation of the proceeding is barred by limitation.
No,
I can raise that question before the.
You can raise all of it,
Yes.
sir. Yes.
List item 39.
39 is also same, Lord.
Same
Because two
order.
purchasers from the same vendor.
List item 40.
None appears. Dismiss is not possible.
Weekly list item number 41. Item number 40, I have put the opposite party.
All right.
Item number 41.
None appears. Dismiss is not possible.
Weekly list item 42.
None appears. Dismiss is not possible.
Weekly list item number 43.
My lord. Paradip Port had allotted a lease in favor of Bharat Petroleum, my lord. During the subsistence of the lease, they asked us to vacate the property, my lord, in the midst of the lease agreement. And in the clause agreement, in the lease agreement, it was provided that in the event of premature termination of lease, the compensation would be provided, my lord. And in these circumstances, I had approached this honorable court for challenging the eviction also, my lord. And this honorable court has passed an order to make an interim make out a settlement it is an order of this honorable court for both the parties to sit and make an arrangement, my lord.
What was the lease period, sir?
It was for 2030, my lord. And I had paid 36 lakhs for the as premium amount also. And in between, I was asked to vacate, my lord. And your lordship may see page 23 of the counter affidavit filed by the internal page 3, 23 running page, my lord. I had asked for a refund of that amount and compensation for that. In this scenario, I have my limited prayer is that I may provided an alternative land so that I can move the other facilities that subsist, my lord.
It's appearing for the.
My lord, I am for the Paradip Port Trust, my lord. But you may kindly see we have filed an affidavit dated, my lord, 22/2/2012. There, while the matter was pending, this honorable court was pleased to direct by an interim order to work out the modality, my lord, how to settle the issue, my lord. That was passed in miss case number 18288 on 28/11/2011. Lordship may kindly see the order. Pending consideration of the miss case, the tender process with regard to taking over the building is deferred for the present, and the parties are directed to sit across the table and work out the modalities of the settlement and come before this court on 12/12/2011, on which date this court shall pass the order after hearing the parties, my lord. Thereafter, a committee was formed, my lord, on 3/12/2011 with the representative of Bharat Petroleum and Paradip Port Trust, my lord. After due deliberation, my lord, there were certain agendas which was agreed by both the parties, my lord. Lordship may kindly see affidavit. We have written the what was decided between the parties, my lord. Para 8 we have written that the port will permit BPCL to flush out the residual oil from the defunct pipeline to the tank by end of January 2012. It was also agreed that BPCL will remove the entire quantity of the black oil in their terminal latest by 30/4/2012. It was also agreed between the parties
All
that
those dates are over now.
Yes, that period is over. Second point, my lord, I'll just place. It was also agreed between the parties that BPCL will approach their management for necessary direction on the issue and revert back to Paradip Port by January 2012. The parties also agreed to place the above fact before this Honorable High Court for compliance. So, my lord, they were to take steps by January 2012, my lord. Thereafter, they have filed an affidavit. They have filed an affidavit, my lord. In the additional affidavit, they are saying that they will complete the work by March 2012. They have filed an affidavit. So it is to them to comply with the terms and conditions of the.
How can they comply, sir? We're in 2022.
This is the development which had happened long back in 2012.
What should happen in 2022?
Now, my lord, a lot of mechanization has taken place in Paradip Port Trust. Everything has changed. A lot of scenario has changed, my lord. If your lordship wishes the present scenario, my lord, I can file an
We
affidavit.
don't wish anything, sir. We can simply dismiss the petition.
I'm sorry, my lord.
Or simply allow the petition. We don't wish anything.
No, my lord,
Should we
but
allow
this-
or dismiss? That's the only
This affidavit was filed pursuant to the direction of this honorable court with regard to the interim order as far as the settlement is concerned, my lord. If your lordship wishes to, the director will file the proper counter affidavit, my lord, with regard to the allegations made.
No, what is, this is 2011 petition, we are
My
in
lord.
22. Are you not supposed to tell us what the current position is?
My lord, this matter has come up yesterday. we
What is
know.
your instruction?
My lord, my prayer is for alternative land, my lord. I have removed the infrastructure, whatever possible.
You already removed it.
Yes, my lord. Whatever possible is there, whatever possible, I have removed it.
No, whatever
And,
possible, my
What
lord.
is that? What is that? Whatever possible means what?
Means, my lord, there are some pipelines which are connected from the ship to offload the petroleum products. And they have put up concrete structures over it, which is not possible to remove it. And other coal. So now with the present scenario, my only prayer is, limited prayer is for
No,
alternative.
Are you working? Are you operating there?
No.
No, my lord. With this scenario, I'm only prayer is for
They can
alternative.
take over this land.
That is a port area, my lord. Without their permission, I cannot enter. So hence, we are not able to operate. So my only prayer is for alternative land, my lord.
All right.
alternative
You
land,
make
my
a
lord.
representation then.
Yes, make him, please. Let him make a
Counsel for the BPCL informs the court that BPCL is no longer operating from the land in question. The only prayer now is for allotment of an alternative land full stop. For that purpose, it will be open to BPCL to make a representation to the Paradip Port Trust not later than 2nd May 2022. Such representation will be examined by PPT and the decision thereon be conveyed to the BPCL not later than 4 July 2022. No further directions are called for. The petition is disposed of.
Equally list item number 44.
With permission, item 42 minutes really, I am for the bank minutes, opposite party.
Who is for the petitioner, sir? None appears for the petitioner. Dismissal not of.
My presence may be noted.
Yes.
45, no instruction.
44.
I am there.
44.
Number 3 here.
44.
Item number
44, we are for the Union of India, man.
I am appealing
for the petitioner, man.
Carry on, sir. If you want your petition to be heard, you have to start speaking.
Here, my lord, the petitioner is challenging the order of the Central Administrative Tribunal, confirming the order of punishment, that is order of dismissal from service passed in the departmental proceeding, my lord. That is under Annexure 16, my lord. The allegation is that the petitioner before lordship was working as a branch postmaster, extra departmental branch postmaster, and the allegation is that he fraudulently had shown withdrawal of some amount from the SBI account of one Sabita Padhi, and subsequently he paid back the amount. On the alleged temporary defalcation, the proceeding was initiated. Falsification of records and other things, my lord. Your lordship may come to Annexure 1. Annexure 1, my lord. That is the charge sheet. I just want to show your lordship. Page 28. Page 28, just before the last para, my lord. As such, Sri K.C. Naik showed fraudulent withdrawal of falsified the BO account under head SB withdrawal and forced the depositor signature on so and so, so and so, so and so. This is the allegation, and for temporary defalcation, the departmental proceeding was initiated. At the same time, criminal proceeding was also initiated against him. The charge sheet, the allegation is 409, and that falsification of records, everything is there, my lord. That is page 34. Annexure 2 at page 34, my lord. Sri Krishna Chandra Naik, while working as extra department branch postmaster for the period from 7/8/92 to 3/7/98, forenoon has misappropriated government money amounting to 16,000 from Bhimpur branch post office, Patrapur SO SB account number so and so, by making fraudulent withdrawals and by falsifying the different government records, etc. my lord. So on same facts, both the proceedings were initiated, my lord. And in the departmental proceeding, ultimately he was dismissed from service, my lord. And the criminal proceeding, my lord, I just want to bring the lordship's notice to the judgment passed in the criminal proceeding, my lord. At page 103, my lord, page 52, I am just placing it, my lord. For the grounds stated above and viewing the cases from its all angle and after consideration of the prosecution case in totality, I am of the view that the prosecution has failed to establish its case under section 409 IPC against the accused postmaster beyond all reasonable doubt, and as such the accused is entitled to be acquitted. Further, I am of the view that this case has been maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spit him due to private and personal grudges. This was the finding of the learned JMFC in the criminal proceeding, my lord. And though they in the counter they say in the before the tribunal that they have already preferred appeal, but no appeal was preferred, my lord. And ultimately, they admitted no appeal was preferred, my lord. And ultimately, my lord, in such a situation, my lord, the question is whether Paul Anthony case is applicable to the present case or not. When it is based on self-some facts, I am quite conscious of the fact, my lord, that
Recent judgments. There are 2 or 3 judgments of the Supreme Court now,
yes, my lord.
saying mere acquittal in a criminal case will not.
But this is the finding that maliciously it has been instituted. This is the finding that remains unsecond, my lord.
Right.
And ultimately, by Annexure 16, my lord,
yes,
the tribunal dismissed the OA
and
ultimately confirmed the order of
the challenge by the petitioner in the present petition is to an order dated 1st November 2011 passed by the Central Administrative Tribunal, Cuttack Bench, Cuttack bracket CAT, dismissing the petitioner's OA number 255/2009, wherein he had challenged the order of dismissal from service. The petitioner was an extra-departmental branch postmaster and was proceeded against by a charge sheet being proceeded against under the EDA bracket Conduct and Service Rules 1964 on the charge of having defalcated amounts from a savings bank's account maintained with the post office. Bimpu. Full stop. Simultaneously, the GR case number 44 of 1999 was registered in the court of the Judicial Magistrate First Class bracket JMFC, Patrapur, for offences under sections 409 IPC. Paragraph. Nearly 2 years after the. This is removal from service or dismissal?
Dismissal. Dismissed from service.
Nearly 2 years after the dismissal from service, the criminal court, by a judgment dated 4th September 2001, acquitted the petitioner and also observed that the prosecution of the petitioner was malicious. Full stop. The petitioner then approached the CAT seeking the quashing of the said order. So, after failing before the discipline appellate authority, the petitioner approached the CAT. In the first round of litigation, ending with an order dated 21st April 2009 of this court, ended petition 76144 of 2004. The petitioner was granted leave to challenge the appellate order dated 24th February 2005, which affirmed the order of dismissal. Stop. Pursuant to this liberty, the petitioner approached the CAT for the second time with OA number 255/2009. Paragraph: the short ground on which the petitioner challenged the order of dismissal was that he had got a clean acquittal in the criminal case, which was on the very same charges, and therefore the punishment of dismissal should be set aside. On two grounds, the CAT has rejected the prayer. One was that the petitioner had not challenged the findings in the domestic inquiry. And therefore, he was stopped from again challenging it. Reference was made to the decision in State Bank of Bikaner in Jaipur versus Nemi Chand Nalvaya, 2011, 4 SLR 458. Paragraph. Further, in view of the law explained in Captain M. Paul Anthony versus Bharat Gold Mines Limited, AAR 1999 SC 1416, it was held that mere acquittal in the criminal case would not ipso facto result in exoneration in the disciplinary proceedings. Paragraph. Learned counsel petitioner reiterates the submission that in view of the clean acquittal by the criminal court and the further observation that the prosecution itself is malicious, this court should interfere with the order of dismissal of the petitioner from service. Paragraph: as rightly pointed out by the tribunal, by the CAT, the acquittal in criminal case, though on the same charges, and though an honorable acquittal will not ipso facto result in the exoneration of petitioner in disciplinary proceedings, particularly since the standard of proof differs. This legal position has been reiterated recently by the Supreme Court in Dash versus Dash. Paragraph: the court is accordingly unable to find any ground to interfere with the impugned order of CAT. The petition is dismissed.
Appearance of open matter along with Mr. Deepak Gucha.
All right.
Weekly list item 45.
45, no instruction.
No instructions.
I'm there for open number 3 year also.
All right.
Weekly list item 46.
Challenging the action of the opposite participant in not alerting the place in question where the petitioner is residing under the slum dwellers rehabilitation scheme. My lord. The father of the petitioner was in the slum to 1976. Thereafter, the government has evicted them and rehabilitated them 92, my lord. And the some of the persons they have been rehabilitated, but the petition has not been rehabilitated. And he alerted administration has alerted a place where the petitioner is staying, my lord. Till date, no action has taken with regard to the allotment of that land in favor of the petitioner, my lord.
What's the stand taken in the counter affidavit, sir?
The counter has not been filed, my lord. But
the counter not filed, my lord.
Kindly
No,
see.
counter has been filed by opposite party number 3.
3 housing board, my lord. Housing board. Opposite by no 3 housing board. Copy not short one.
All right. What have they said?
My lord, here, Dr. kindly see 2 writ applications are there. My lord, in the writ application number 32345, my lord, which is the first one. Here, my lord, he is challenging annexure 7 at page 18. This is a notice issued by the Orissa State Housing Board. The content, my lord, is that he has unauthorizedly encroached government land, which is earmarked as a road in the layout plan, my lord. Therefore, it was directed for a joint verification by the BMC and the State Housing Board. Another notice, my lord, page 21, a notice under the Orissa Public Premises Eviction of Unauthorized Occupant Act, my lord. He has encroached upon government land for which notice has been issued. So he's challenging that, my lord. Liable for eviction because he's unauthorizedly encroaching upon the government land, my lord.
No, he says somebody else has got relief.
Yes.
And only his.
Annex 3.
Yes, that is his only ground that adjacent land has been granted in favor of somebody, my lord. That is also to be ascertained. Is only he has taken a averment that the land which is adjacent to the petitioner's land has been allotted in favor. Let him make a representation in that regard, my lord. That has to be made to Odisha Housing State Housing Board also.
Voter list shows that you do not belong to Satyanagar, sir. You say you're resident of Satyanagar, but the voter list does not show your name. That's what.
Yes, my lord. I have given the voter list, my lord. I am belong to Satyanagar. My voter list is there, my lord. Your lordship. I'll see the voter list, my lord.
Petitioners filed this petition.
Yes.
Direction to, no, to quash a letter dated 7 June 2011 issued by the Orissa State Housing Board, including the land occupied by the petitioner, Khata number 421, plot number 354 at Satyanagar, of an extent of in the joint eviction program of the Bhubaneswar Municipal Corporation, like a GMC. While directing notice to issue the present petition on 16th December 2011, this court directs status quo to be maintained. That interim order is continued. The only grievance of the petitioner is that the person occupying the adjacent plot has been allotted the plot itself by the BMC, whereas the petitioner is not. So the stand of the OSHP, opposite party number 3, is that the petitioner had forcibly occupied government land and that too after the adjacent land had been regularly allotted in favor of its occupier. Paragraph B, that is, it may, since the limited grievance of the petitioner is regarding allotment of the land under occupation by him in his favor. And since there is no denial of such allotment being made in respect of an individual, as far as the adjacent plot is concerned, the court considers it appropriate to direct that if the petitioner makes a representation to the OSHP for allotment of the land of this occupation, it should be considered on its merits and an appropriate order should be passed. And communicate to the petitioner within 2 months from the date of making of such representation. The petitioner is directed to make such representation not later than 2nd May 2022. The court clarifies it has not expressed any opinion in the matter. If agreed with the decision of the BMC, the OSHP, it will be open to the petitioner to seek appropriate remedies in accordance with law. The status quo order passed today, passed earlier by this court, will continue till the disposal of the representation of the petitioner by the OSHP, provided the representation is made not later than what date? 2nd May. 2nd May 2020. The petition is disposed of later.
I am appearing for up to 4 million. My
My appearance maybe.
Weekly list item number 47.
May I please, Your Lordship, on behalf of Mr. R. Achari, I'm for the opposite party. 1 week time
All
may
right,
be.
who's for the petitioner? None appears for the petitioner. Dismiss in opposition.
Weekly list item 48.
None appears for the petitioner.
Wait, please, Your Lordship. Lordship, here I am challenging the constitutional validity of section 16, clause 3A and 2A of Odisha Panchayat Samiti Act, which is in direct contravention to the judgment of Honorable Supreme Court in constitutional bench judgment of K.V. Krishnamurthy versus Union of India. My Lord, here in the present case, my part of my prayer is already infructuous as the present petitioner was one of the aspirant for the post of chairman in the Panchayat Samiti.
That's all over. That election was over.
2012 election.
My Lord, that is of 2011. So I'm not placing that aspect, my Lord. But my part of prayer is regarding the ultra virus of the section 16 of the Panchayat Samiti Act.
Yeah, but it can't be in a vacuum, sir.
My
There has
Lord,
to be some
my
context.
Lord has already dealt with such matter, but that is relating to section 10 of Odisha Gram Panchayat Act. But this
Sir,
is
unless there is
relating,
a context, we can't have an academic.
my Lord, that is true, my Lord. But this aspect is still,
Yeah, we leave that
my Lord,
open. You raise it in an appropriate petition.
my Lord, there is already, they have formed a committee, but that is of 2011. They are not doing anything.
Whenever you find a candidate who's contesting, who's going to get affected by the rule, you challenge.
My Lord, considering that aspect, my Lord, Lordship, this court has directed the opposite party to file the counter. My Lord, may please see the last order, my Lord.
Sir, are you following what I'm telling
My
you?
Lord, my Lord.
What is your answer to that? You don't have a candidate whose election is going to be affected by the impugned rule, correct?
My Lord.
My Lord, as and when you find such candidate, there will be a cause of action, you can always challenge.
Lord, but my prayer only to the constitutional validity, my Lord.
Yeah, that will examine
That
some
is
other
my
matters.
only prayer.
We'll examine it in some other matter. The main prayers of the petitioner have been rendered infructuous on account of passage of time. As far as the challenge to the validity of section 16 3-A bracket 1-A of the Orissa Panchayat Samiti Act 1959, it will be open to the petitioner to raise a challenge as and when any fresh cause of action arises. Petition is disposed of the above.
Weekly list item 49.
Challenging the cancellation of lease. I am the purchaser from the original lessee. So order passed in item number 39.
Same order.
Lord, original lessee is not a party.
Yes. I made party or opposite party number 5.
No.
Yes,
Yes,
after-
noting, my Lord. Requisite for issuance of admission notice on OP number 5 is not filed.
I have filed a petition for substituted service to issue notice to the opposite party number 5. As it was not served on the opposite party number 5, for that purpose, I have filed a petition before this honorable court to allow me to serve the copy through substituted service. So
Anyway, it has to go back.
My Lord, the order has been passed in 98 and he is stated to have purchased the land in 91.
See, the same order as in
Yes, my Lord.
Order item number 39.
39. Same order. You have
39.
to add a line since the opposite party number 5, that is the original lessee, was unable to be served in the present proceedings. The ADM will take appropriate, will require the appropriate steps to be taken in that regard in those proceedings. Right.
Expeditiously.
Weekly list item number 50.
In 50, my Lord, we are for the petition, our name may be deleted as the brief has already been transferred.
All right. He says the briefs have been transferred. The name is deleted. None appears to the petitioner. This is not. Okay.
From 50, in fact, this is correction of my lord's order.
Which one? Oh, it's already been disposed of.
Yes.
Okay. Oh, MC number. So you say MC number 356 of 2003. You say the office note has been produced. the disposal order will be read as in MC number 356 of 2003. The order will read, open quotation, the application is dismissed for non-prosecution, unquote. All right. Supplementary.
Item 1, no instruction.
Supplementary list stress admission. Item number 1.
Item 1, no instruction.
No
With
instruction.
liberty.
No liberty, sir. No instructions, no instruction. All right.
My matter relating promotion, I contacted last night, but as the mobile phone is not reachable.
It's all right, sir. If they're interested, they'll always file. You don't have
Already
to give
junior
liberty.
person are promoted, my lord.
Sir, we don't have to give liberty. If they're really agreed, they'll come to the court. Yes.
Supplementary list item number 2.
Item number 2, brief was transferred, Your Lordship.
Brief has been transferred. None appears.
Supplementary list item number 3.
None appears. Dismissal non-prosecution.
Supplementary list item number 4.
May be permitted to withdraw, my lords. With the liberty to file.
Leave to withdraw this petition. Dismiss this.
Liberty may be granted, my lords. In view of the amendment of the Motor Vehicle Act, my lords, I challenge the earlier provision. Now a new amendment.
It's all right, sir. No liberty is required. Yeah.
Supplementary list item number 5.
5, 6, 7 well passable, my lord. On behalf of Mr. S.K. Das, my lord.
All right.
Supplementary list item number 8.
None appears. Dismiss non-prosecution.
My lord, there is a contempt.
Contempt is disposed of.
Maybe drop.
Supplementary list item number 9.
None appears. Dismiss non-prosecution.
I am appearing on the opposite party, my lord. Mr. Chimanka appeared on the opposite party.
Who's the petitioner?
P.R. Mahanti. It is a 148 matter that it will list out on 11/7.
Okay. List on 11/7. It will moderate to continue.
Supplementary list item number 10.
May I please, your lordship? Lordship, section 148 notice challenge.
Same, 11/7.
July. No coercive action. No coercive action.
No, yeah, notice, no course of action. 11/7, reply within 4 weeks, rejoined up to next. Same order.
Supplementary list item number 11.
May I please, lords. Here the petitioner has challenged annexure 11 at page 48. The order passed by the appeal committee without taking into consideration the grounds taken in my appeal. My appeal, I have read for expansion of my adverse entry in my CCR because it was made without following the procedure as provided in the circular, book circular 46. But that has not been taken into consideration. And the appeal committee.
But when are you challenging all this?
My lord. Annexure 11 I have challenged.
No, you're challenging all kinds of annexure 5, annexure 7,
Because
annexure
the,
11.
that is the CCR and annexure 7 and the rejection order. The CCR annexure 7, which was prepared without following the book circular. Annexure 7 is page 30.
Just come to the appellate order, sir.
My
Annexure
lord.
11, please come to annexure 11.
Annexure 11.
Just read it.
My
What
lord.
is wrong with it?
It has not discussed the committee has not discussed the grounds taken in my appeal memo that the.
You just read on a thorough and careful scrutiny.
On a thorough, I may permitted to last paragraph.
Yeah, I'm asking you to read, sir.
My lord.
I ask you to read, then you ask my permission to read. I again permit you to read. Now you please read.
This appeal has been prepared by Sri Achal Chandra Pradhan, ex-junior clerk.
No, on a thorough and careful
On a thorough and careful scrutiny of all the aforesaid materials placed before us, there hardly appears any lacuna, shortcomings, illegality or impropriety in the orders of the district judge passed in respect of the representation filed by the appellant from time to time Apparently, all such orders are wholesome and same have been passed judiciously, taking into account every aspect of the repentations. There appears no reason, let alone a justifiable and logical one, to interfere with any of the impugned orders. We are therefore of the firm opinion that none of the prayers appellant merits any consideration, and accordingly the orders passed by the district judge Mayurbhanj not giving promotion to the appellant notionally and rejecting the repentation filed from time to time do not call for any interference by this committee. Lordship, may kindly see that Annexure 7, I have prayed for passing of that also. Annexure 7. I have prayed that has been made without following the procedure laid down in the book circular. Lordship, may see the Annexure page 30. This is the adverse entry communicated to the. I am directed to communicate the following that was made on 28/6/2003. I am directed to communicate the following remarks made in your CCR for the year 2000 to 2002. When I was not there, Lordship, may see that book circular. I have annexed also Annexure 6. Annexure 6. Page starts from page 26.
Not legible.
Plus 3, your Lordship, may see. Report period. Page 27. It is in page 27. 3, report period. The character roles will be maintained financial year wise, and the report period will be from the 1st April to 31st March. No remarks should be recorded in CCR before 31st March, except in the event transfer of the officer recording the comments or the employee himself. Next, your Lordship, clause 5. Deadlines of the submission of the CCRs. The reporting authority shall initiate the CCR immediately after 31st March and submit it in duplicate to the countersigning authority by the 30th April. The countersigning authority will record his own assessment and forward it to the 15th May to the accepting authority. The accepting authority will record the assessment and forward the CCR to the appointing authority by 31st May. When the CCR, here I have been transferred in the meantime that period, when the CCR are written in the midst of the report period, as a result of the transfer, it is expected that the CCR will reach the office of the appointing authority within 2 months from the date of transfer. But here the CCR of the 2002 have been made in the year 2003. When I was transferred from SDGM Karanjay to Udala on 18/9/2002, I was not there even. So the CCR maintained against me is contrary to the circular. That is why I had prayed for that expansion of that remarks and the consequential benefits.
This CCR was communicated to the petitioner on 28/6/2003.
Yes.
Thereafter, you Lordship, page 28A.
No, but tell us the first point he's making is the CCR was entered for the year 2000 to 2002, but it's being entered in 28 June 2003.
This is the communication letter.
No, signed SDJM.
Yes. This is the letter which was communicated. The adverse entry was communicated to the petitioner.
What? No, when was it entered?
Well, as to when this was entered, that is not there. That instruction I have to obtain.
So we don't know when it was entered.
That was the communicated
for
to me
2
on
years.
that day.
No, he's saying
So
for
that
2
is
years
communicated.
continuously can you put one entry for 2 years? This rule actually requires, just see that, report period, page 27. It will be maintained financial year wise and the report period will be 1st April to 31st March.
Well, probably that may be consecutive 2 years.
No, no, can you find out? Get the original.
Yes, I will obtain instruction.
The originals of the records of the District and Session Judge Mayurbansh Baripada shall be requisitioned by the opposite parties in order to ascertain whether indeed the adverse remarks entered in the petitioner's CCRs as communicated to him on 28th June 2003 was made by the SDJM Karanjia for the years 2000 to 2002. Stop. This is in the context of the submission of the petitioner that in terms of the instructions issued by the General Administration AC Department of the Government of Orissa dated 5th February 1982 Annexure 6 character roles are required to be maintained year-wise, and the report period has to be from 1st April to 31st March. Stop. No remarks are to be recorded prior to 31st March, except in the event of transfer of the officer recording the comments or the employee himself. Paragraph. Mr. Mudali seeks time to take the above steps and inform the court on the next date. The record be kept ready for perusal by the court on the next date. Based on 28th June.
Supplementary list item number 12.
Council petitioner seeks leave to withdraw this petition.
Supplementary list item number 13.
Yes, ma'am. My lord, in this case, I have filed miscase, my lord, to regarding
defect.
Removal of defect. My lord, this may be.
What is the defect number 22?
That was not written. Grounds was not met. In the petition. I have prepared the grounds and also filed the petition, my lord.
There are still two defects, 7.2 and 14.6. Not removed yet.
That is not written in the capital letter, my lord.
Sir, it's all handwritten and everything. Sir, all this is civil suit you have to file, sir.
No, my lord, it is
big apology or something you're saying?
Yes, my lord, it is in the as against the Nestle company, my lord.
Sir, you have to file a civil suit, sir, for these things.
My lord, we have filed also FIR for cantonment.
No, you file a civil suit. This all evidence has to be laid for this.
No, my lord, this is regarding the
Sir, we are not here to give free legal advice, but you have also to listen to what the court says. Writ under 226 cannot be issued to Nestle and Nestle Company Limited and all that. They are not amenable to 226.
State of Orissa.
Something, sir, some law has to be followed. Everybody comes to you, you say, yes, let's go for 226. Straight away. How is Nestle India Limited amenable to
State of Orissa is party, my lord. Culture department.
So everything, sir, the main relief is against Nestle India. All right. But you put State of Orissa on the top.
No, my lord, in the Orissa.
So if we delete Nestle India is not amenable to 226. Is it or is it not?
Yeah.
What is yeah? Yes or no?
Yes, ma'am.
So if you remove Nestle India, nothing remains. You don't get any relief.
It is state of Orissa to take action against Nestle.
No.
That is the sentimental.
This is a civil suit. You're asking an injunction against them. Counsel, the petitioner.
My lord, I have filed a FIR before the cantonment.
That you pursue, sir. No problem. You pursue
that might be with that observation, my lord.
Now, what for? No need. You have a FIR. You pursue that.
We have filed, my lord, and accept mine.
That's very good. All right. Counsel, the petitioner seeks leave to withdraw this petition, liberty to pursue other appropriate remedies as may be available to the petitioner according to the law. Disposed of his withdrawn liberty is paid for. Right.
Supplementary list item number 14. Supplementary item 14.
It is public in litigation. It is second time it was also filed. Last occasion it was filed, withdrawn. We'll just pass it over once.
Supplementary list item number 15.
May I please, my lord? My lord, in the morning I mentioned, these are the cases I have filed challenging the notice under section 140. And the first case, item number 15, here, it is barred by limitation, more than 6 years are elapsed, then the notice has been issued.
All right, covered by our
Yes, sir.
Amitayan.
Yes,
All
sir.
right.
I've given the copies of the judgment.
Where are those orders, sir?
Ambika item number 9 already.
Are you mentioning item 9, sir?
Item 9. Item 9, my lord, I may be forgiven. I was here. I went to the washroom by the
So
time.
no, anyway, now you're mentioning item 9.
By mistake. Item
9
15
is
is also
PCIT,
said,
my lord.
more than 6 years. Item 15.
Mr. Chimanka, he says it's more than 6 years.
No, no, no.
In fact, it is
Approval
more
is
than 7.
PCIT.
Sorry?
PCIT approval is there.
No, more than.
More than 6 years, sir. More than 7 years after the end of the assessment year.
It is 30th March 2021.
Yes. Assessment year 13-14.
13-14.
So it's far more than 6 years. So item 9 is covered by that order. Same order, that more than 6 years. And item 15? Same. All right. Item 15 also is allowed. All right. All right.
Then my lord, item number, double piece number 7749-2022, 3691-981-2021, 723-2022. All these three is also more than 6 years covered by the same.
No. One is within the 8150. That is 14-15 within 6 years.
8150
8150 of 2022. That is within 6 years.
The notice is issued on 28, but it was dispatched on 31st, received more than beyond that. The law says it should be issued and served. That is the reason why I have got it. It is more than 6
That is
years.
something different, not as good as the submitting. The notice lot assessment year 14-15, date is 33/2021. So it is within 6 years.
It is not served to me within the period of limitation.
The act says lot.
These are not even listed here, sir.
These two I can argue.
It is not mentioned. You are fixed on the.
So these three you mentioned, let it come on board, sir. Otherwise
Yes,
it gets
My
confusing. for
lord,
us tenors also.
not this one. But the other one are old cases. That is 7749-2022, 36981, and 723, and 4114. These are old cases. They are covered clearly.
Yes, that is correct.
That he is also agreed, Your Honor. My lord.
All right. So you leave out 8150 and 8152. So taken on board, you take 7749, 36981 of 2021, 723 of 2022, and 4111 of 2022.
And my lord, 4114-2021.
The
is,
JCIT.
JCIT has approved. It's
4114 will be the JCIT order. All right.
and that is covered by this.
All right, sir. All right.
Let's see 8150. Let's see.
No, we're not taking up those two. 8150.
That can be
Let
taken.
it come up on its own. Yes.
Highly obliged, man. Your Honor.
Supplementary list item number 16.
Password.
1617 IF for withdrawal has been.
Oh, memo. Yeah, the memo is taken on record. Both these 16 and 17. Both these are dismissed as withdrawn in terms thereof.
Supplementary list item number 18.
May it please your lordship. My lord, here at annexure 1, page 8,
He has not been served.
here the parties are the administration of the High Court. So
Yes. State is different.
no, state is not.
State council.
Here, my lord, my appointment was I was appointed on 20th December 2019 in the post of system analyst, and the petitioner was given a charge on 6th of January and the work schedule, and on 7th of January by a one-line order he was terminated without recording any reasons as was required in the appointment order. My lord, the appointment
You made
order,
a representation.
my lord, appointment order is at page 8.
No, you've made a representation.
It is on the administrative side of the High Court, but it has not been considered till date since.
Copy has not been sought to us.
I'll serve. I didn't know the status.
All right, a copy of the petition be served on Mr. Mudli to enable him to seek instructions. We'll have it next week.
My lord.
List on 7th April.
But can it be on 8th?
All right, 8 days. All right.
Obliged.
Supplementary list for admission, item number 19.
May I please? Sure, I am appearing for the petitioner. On the last occasion, your lordship has directed document number 1 and 2 to remain present and take instruction in motion.
Are they present? Arsil is present here.
Arsil, my lord, my friend is here.
I was earlier reading for this Arsen Mara, but they have taken away the books.
Oh.
And no more there.
Okay.
There was in fact a communication gap, my lord, that is since in view of assignment, I was under the impression that Arsil will argue. Now I am appearing for opposite party number 2, that is the bank.
What's the position now?
The position is, my lord, so it has a very secured career. My lord, at least 10 writ petitions have been disposed of in the meanwhile. Here he has challenged the assignment to Arsil. Under the provisions of the Act, Section 5, particularly under the Securitization Act, the account has been already assigned as early as on, my lord, 2008, my lord. And a DRT proceeding was filed by the bank in the year 2004. All the original documents, including the mortgage documents, were filed before the DRT as early as in 2004. Subsequently, Arsil made an application to get substituted by virtue of Section 5(4), and substitution has been allowed. And that is the case. And now Arsil is
the interim order of this court, 7th April, says that the bank shall retain the mortgage documents.
Here, what has happened, Miller, since 2004, the bank has already filed those documents before the tribunal.
So you cannot retain it.
Yes, and the tribunal is already in the session of the matter. And Arsil, after taking over the
so why can't you go before the
2008,
tribunal? Why can't you go before the tribunal?
Sure, I am before the tribunal. The bank has filed a OA in the year 2004 that is pending till date. During pendency of that OA, the entire debt has been assigned to Arsil without taking my consent, and there is no clause in the agreement enabling the same, your lordship. There is a violation of natural justice. That is why
that can be argued before the DRT.
May I pray, my lord? Here, in fact, the agreement, in the agreement, they have given up their right on.
Anyway, all that can be examined by the DRT.
Under section 134, 135 and 36.
Even in DRT, the entire application for substitution are allowed without hearing me, your lordship.
So you
there is a violation of natural justice.
You either challenge that order or you apply for a recall of that order. There are provisions for that.
Your lordship, under section 133.
Or you can file an appeal before the DRAT. You are the borrower, right?
I'm the guarantor, your lordship.
Guarantor,
but even guarantor can go.
Same.
Even the guarantor can go before the DRAT.
Your lordship, the proceeding is pending. I have urged that ground before the tribunal, your lordship. That was rejected.
See, the only interim order passed here is for them to retain the mortgage documents. That cannot be now worked out because it's already with the DRT, the mortgage documents.
Your lordship, my entire grievance is under section 133 of the Contract Act. I am. Your lordship, may I be permitted to read?
But why can't you argue this before the DRT? That's the question.
I've already argued, your lordship.
What is the order passed by the DRT? Show us that.
Your Lordship may give me one occasion, I'll produce the order.
No, not like that, please. And if you're agreed by the DRT's order, you should have gone to the DRA.
Your Lordship, I'm not agreed by the DRT's order. I'm agreed by the action of the bank assigning entire date without giving a notice or
No, so the
without taking a
DRT
consent.
rejected your prayer in that regard.
Borrower here. In fact, she is the guarantor. Now we are conflicting against each other. Guarantor says that the liability has been transferred to the SARFAESI that are sale without putting a notice to the guarantor. But your lordships are correct in saying that these pleas he can take before the DRT.
Correct.
And your lordship can direct the DRT to deal with her grievances.
All right. The petitioner's only grievance at this stage, the petitioner who's the guarantor for the loan, advanced to, you are which party, Mr. Ratha?
But I am appearing for the
Opposite part number 3.
OP number 3.
Loan advanced to opposite party number 3 is that the loan was assigned by Union Bank of India, bracket opposite party number 2, to the Asset Reconstruction Company, bracket India, bracket Limited, opposite party number 1, without the consent of the present petitioners, who are the guarantors. Paragraph. Counsel for the petitioner states that when the petitioners ventilated this grievance before the DRT, it did not agree with them. However, the order passed by the DRT in that regard is not before the court. If the petitioners are aggrieved by such order, they ought to have filed an appeal before the Debt Recovery Appellate Tribunal. Nevertheless, if there is no such formal order of the DRT rejecting the prayer of the petitioners, it will be open to them to urge such prayers before the DRT in accordance with law in the pending proceedings. No further orders are called for in the present petition. It may be noted here that by an interim order dated 7th April 2010, this court had required the Union Bank of India to retain the mortgage documents furnished by the petitioners till the conclusion of the case. So today, counsel appearing for the UBI informs the court that way back in 2004, the mortgage documents were already made over to the opposite party number 1. And therefore, the said order could not be given effect to. The petition is disposed of in the above terms.
Should direct the DRT to deal with her points because she raises a point that her liability stand discharged. That may be dealt with by the DRT.
Sorry?
She raises a point that her liability stands discharged since it has been transferred without her consent.
All right. All such pleas, I've already said that. She can raise those pleas.
DRT will deal with that.
The plea of the petitioners that their liability stands discharged on account of transfer of the loan to RCL without their consent will be considered in accordance with law by the DRT.
That's
right.
One small correction, my lord. Loan has been assigned in the year 2004, but as early as in 2008, but as early as in 2004, the documents have been filed before the DRT in the original.
Okay, the documents, mortgage documents have been filed with the DRT.
The receipt I'm giving, copy of the receipt.
All right.
Supplementary list item number 20.
I am for the OP number 4, your lordship.
Yes. None appears to the petitioner. This was not prosecution.
Supplementary list item number 21.
The interim order stands for case.
Item number 21.
None appears. This is not prosecution.
Supplementary list item number 22.
I am for the OP number 3 and 4.
All right. None appears. This is not prosecution.
Supplementary list item number 23.
My lord, this matter, I unfortunately have had food poisoning. I can may be accommodated today only, my lord.
Item 23.
Yes, my lord. I really had a bout of food poisoning.
Mr. Yashwant Das, senior counsel appearing for the petitioner, is unwell today. List on 20th April, 20 April.
Yes, sir.
Supplementary list item number 24.
24, my lords, I appear on behalf of the university. As on date, my instruction is the relief claimed has been granted. This is letter petition
All right.
treated
It
as a
says,
writ
Counsel, the
petition.
university informs the court that the petition has already been granted the relief prayed for. The petition is disposed of.
Supplemental list item number 25.
None appears dismissed from prosecution.
Supplemental list item 26.
None appears dismissed from prosecution.
Supplemental list item number 27.
20 in May audible. In 27 item, it is not a PIL, my lord.
Whom are you for, sir?
I am for the villagers, my lord. This is a case for against the order of BCP case, my lord. Boundary change proceeding.
No. Which item are you appearing in, sir?
27, my lord.
No. What's the item, writ petition number?
Writ petition number is, my lord, 4748 of 2014.
All right.
This is a case against the under order survey and settlement act, my lord. This is case for boundary change proceeding. I challenge the annexure 14 and 15, my lord. This is case. This is not PIL. If your lordship will hear it, then I will.
Counsel, the petitioner states that this is a matter before for the
Yes.
First stage.
Supplemental list item number 28.
My lord, this is an entry tax matter challenging the constitutional validity of Orissa Entry Tax Act, and it is covered by the Supreme Court judgment dated 28/3/2017.
All right. Counsel, the petitioner states that the matter is already covered against the petitioners by the judgment dated 28 March 2017 of the Supreme Court of India, upholding constitutional validity of the Orissa Entry Tax Act. The petitions are accordingly dismissed.
Obligement.
Supplemental list item 29.
None appears dismissed from prosecution.
Supplemental list item number 30.
My lord, the impugned order has been passed by the Honorable Justice R.K. Patnaik. Therefore, the matter may be heard by any other bench.
List before a bench of which Justice Patnaik is not a member on 21st April.
Supplemental list item 31.
May I please, Your Lordship, I mean BC, my Lordship.
Yes.
Lordship, this is the first item, WPC PIL 29891 of 2020, my Lordship.
Right.
This the matter relates to public interest litigation, the construction of Orissa Adarsha Vidyalaya at Nuaga in the district of Nayagarh, my Lordship. Kindly have a glance to answer 4 series, my Lordship, at running page 26 to 29. Here, my lord, the spot verification was made by the opposite parties, and may I read the second paragraph, my lord? During demarcation, it is found that only an area of 3.3 decimal is available instead of 10.40 decimal in the proposed site. The rest area of 7.10 decimal is full of trees and mountains. So the executive engineer PW Nayagar stated that the proposed land is not suitable as for construction of Orissa Adarsha Vidyalaya Nuaga. And also in their first letter, they have rejected the same to construct the Orissa Adarsha Vidyalaya.
What are the instructions, Mr. Murli?
Well, I have already filed the counter affidavit. Your Lordship, may kindly say paragraph 11 of our counter affidavit that is available at page 45. Counter affidavit by Tahsildar. Paragraph 11. May I placement?
Some other sites were selected. We visited the sub-collector, Kochar and Kisam.
Detail we have explained. Well, may I place that paragraph? It is submitted that the site selected in Mauja Nuagaon for construction of Orissa Adarsha Vidyalaya Nuagaon earlier was approved by the site selection committee on 12/3/2018. But in course of demarcation, the said selected site as per sketch map was not suitable for the aforesaid purpose due to existence of trees and mountains of an area of 0.7.10 decimal. Thereafter, some sites were selected in Mauja, Kachapalli, Mohitama, and
You
Nuagaon.
already located properly. By now, you should have started construction then.
No, because of interim order, we are not able.
What is interim order?
In the connected matter, there is a status quo order.
Oh, I see. What is wrong with this site, sir?
My Lordship, kindly have a glance to their counter affidavit at para 11, my Lordship.
That's what we're just finished reading para 11.
In the last portion, they have stated that the selected land was full of trees and mountains as per case map of that big plot number 1 of an area 125-20, but an area.
No, the selected site in Nuagaon and Ambajari has been properly verified.
Yes, Your Lordship. But after
revised map was submitted by the authority.
Under annexure proof, they have rejected that same area, my Lordship.
Anyway, they've now selected it. So what's your problem?
My Lordship, though that was a hilly area and the pool of trees. So
now they've done it, sir.
But school, my Lordship, over that area, my Lordship.
It's all right. They'll take care of it. You see, from para 11 of the counter affidavit, it appears that
Annexure 10 is pending, my Lordship, before the authority. Let it
it's
be
all right, sir. We're not interfering. The dispute raised in the present petition is about the suitable location for the construction of a Adarsha Vidyalaya in Nuagaon. Full stop. In response to the notice issued in the present petition, a reply has been filed by the opposite party state. So in para 11 of the reply, it is explained how the selected spot of Moza, Nuagaon, and Ambajari have been now properly verified by the site selection committee and found suitable for construction of the Adarsha Vidyalaya. Stop. Concept of the petitioner states that earlier this very site was rejected for having a large number of trees. So how now that the site selection committee has found the site suitable, it is up to the state to make it feasible for a school to come up on the site. No further directions are called for. The petition is disposed of. The connected matter is the same thing.
Yes, same thing.
The order passed today in 29891 of 2020, the present petition is also disposed of. The interim orders vacated.
Madam, in the connecting matter, madam, I am the virtual. In the connecting matter, I am appearing for opposite party number 1.
All right, sir.
My appearance is very noted.
All right, sir.
Supplementary list item number 32.
May please, Lord. My Lord, I'm appearing through the VC.
Yes.
The opposite party number 3 has filed a counter affidavit. My Lord, I need 2 weeks time to file a rejoinder to it.
What's the matter about, sir?
It is regarding, my Lord, arbitrary levying of holding tax on the owners of the.
All right. Rejoinder be filed the next day.
I am appearing for the opposite party number 3, my Lord.
All right. List on 22nd July.
Name may be recorded.
Supplementary list for admission item number 33.
My Lord, item number 33, 34, and 35 can pass over, my Lord.
All right.
Item number 36.
May I please? Yes, sir. Before I take your lordship's words to the question involved, my lords. Yes, unlike IPR 89, where your lordship knows, my lords, the exemption is available in respect of, my lords, purchase of raw materials and sale of finished product for a period of 7 years, my lords. Yes, in case of 92 IPR, my lords, the one your lordship is concerned here, my lords, the modality of grant of exemption is, my lords, total exemption in respect of purchase of raw material and sale of finished products shall be limited to 75% of the capital investment, fixed capital investment. So that will be calculated, certified by the district industry center in the same manner, like they certify earlier in other cases. And based on that amount, eligibility shall be claimed. So far as eligibility concerned, there is no dispute. Only question is how to calculate the eligible amount for the purpose of set off against the eligible total eligibility amount. That is 75% of the capital peak capital investment. Because earlier, our sales tax tribunal full bench has decided that once you are getting exemption on raw material and finished product 70%, no other concession shall be allowed to. You cannot go hand in hand. This was reversed by our High Court. In Louis packaging case, our High Court said, referring to a judgment of Gujarat, Honorable Gujarat High Court. Gujarat High Court dealt in your threadbare, and our High Court has also. This Honorable Court said that forgetting for a moment any exemption available to an entrepreneur, because what would have been otherwise the liability had the exemption not been available, that will be worked out first. And that amount will be set off against the eligible amount. The point of submission would be, supposing a registered manufacturer, because under IPR, I have to furnish 1D92 to avail exemption purchases, full exemption. Supposing this exemption would not have been available, then I would have been eligible to get raw materials at concessional rate against Form 4% to avoid cascading effect, because manufacturer cannot pay full tax on raw material and again full on finished products. So this Honorable Court said that the concession otherwise available, that is 4%, will be the liability which will be set off against the total available eligibility amount. That is how Your Lordship, referring to RDEC, has decided. Now, my Lords may kindly see the question involved. Page, my Lords, 13. 1-3 minutes.
Questions have not been framed yet.
Lords, I think, yes. This is admitted. My question is question is not framed, Your Lordship is correct, but my case is admitted. That is 17/7/2008 order, Your Lordship.
Correct. I just saw that.
Yes.
So we'll have to frame the question.
Yes. So the question involved is, which I have framed, the only question, page 13, my Lords may kindly see. Only one question. A, whether in the facts and circumstances of the case, the raw material purchased by the petitioner for the purpose of adjustment of eligible exemption amount as against the certified exemption limit in terms of entry 42A, 43 may kindly be read as 42 years. 42A of the Finance Department notification number so and so, dated 23/9/92, is to be calculated at the rate of 16% as held by the tribunal, as against the rate of 4% claimed by the assessor. This is the limited question involved. For that, Your Lordship may kindly see first eligibility certificate. There is no dispute, so therefore Your Lordship need not, because tribunal has also accepted. Everyone, nobody cares that I am not eligible. Now, Your Lordship may kindly talk the finding at page 28, my Lord, of the tribunal. Paragraph 8, my Lords. There's only one paragraph with my Lord's permission, I will place the Lords.
Para 8.
Para 8 at page
4.
Running page 4.
Right.
Internal page 4, running page 20, minors.
It's fairly manifest.
Minors. It is fairly manifest from the order of assessment, the order of the Lord SCST and the grounds of appeal, that the appellant is eligible for exemption of sales tax, both in purchase of raw materials and spare parts of machineries and sale of finished products to the tune of rupees 11,66,928 for a period of 5 years with effect from 6/1/96. One cannot lose sight of the fact that the appellant has already availed tax exemption of 10,79,821 till 31/3/97. The Lord SCST has therefore rightly observed, hence the appellant is eligible to purchase manganese ore on the strength of Form 1D92 to the extent of 5,44,418.75 in view of the fact that the tax concession availed in the process of purchase has been worked out to 87,107, as manganese ore is subject to levy at the rate of 16%, as per serial 69 of the rate chart. The contention taken in the memorandum of appeal that the rate should be calculated at 4% instead of 16% is legally untenable, in as much as the appellant has opted to avail tax exemption under IPR 92, and the unit being located in Zone B was entitled exemption of sales tax both on purchase of raw materials and spare parts of machinery and sale of finished product, limited to ceiling of 70% of the fixed capital investment as per entry 42A of the exemption schedule, exempted schedule. The Lord SCST observed accordingly, the Lord SCST has rightly added the said amount to TTO and levied tax at 16%, and since the appellant has exceeded the ceiling of tax exemption, the Lord STO rightly levied tax on the sale turnover of 52,800. It is pertinent to note that the appellant liable to pay tax at 16% on purchase raw material of 6,13,404.87, as it has misused, it says misused, declared by 1D92. In the premises, computation of GTO, TTO, extra demand at rupees 9 lakh. These two lordship may kind of omit. Here tax demand is 1,06,593 assessment under 12 for West Act, and confirmation of the same in the first appeal are just proper legal with therefore no impairment. Now I will straightway take your lordship's attention to the judgment of our High Court, which I have given yesterday. Two judgments I have given. One Louis packaging case, page 12, 13, 14, 15 minutes. That's paragraph 12.
Yes.
From Louis packaging.
Yes.
In the facts of the present case, we have to consider the basis on which the assessee is entitled to claim exemption. What is the mode and scope of provision under which the demand of exemption availed is to be worked out with reference to different provisions to West Act. In the aforesaid case, the self-same stand as taken by the revenue herein was raised for consideration. It is worthwhile to note the conclusion raised by Gujarat High Court in para 25 and 26 judgment, which are quoted here below. If your lordship may permit to skip 25-26, and your lordship may now kindly turn to para 13. I am keeping reserve. If necessary, I will go to those paragraphs. We have further come across division bench judgment in the case of Kerala High Court on the self-same issue in the case of P. Narendra Menon versus Kerala. Then in the para 14, in view of the facts and submission noted herein above and the light of the case law cited, we are of the considered opinion that when the state government issues a notification for providing concession in tax, it will be assumed that the government is well aware of the concessions otherwise available to the dealer under the Act, and whatever is given under the notification is over and above what is provided under the statute. In other words, when the benefit under the IPR 96 was promulgated, with new industries becoming entitled to exemption from sales tax on sales and purchases, it has to be assumed that the state government was well aware of the concession otherwise available to dealers under the West Act 1947, and that the benefits under the IPR 96 was over and above what was provided under the West Act. We are taking a pause here. That judgment deals with 96 IPR. 96 IPR also contains similar provision as that of 92, that fixed percentage of fixed capital asset. Here 70% for zone B, that is also equally there under 96. The basis is same. Unlike 89 IPR, where exemption available in respect of for 7 years without any limit to all raw materials and finished products. So 96 as well applies to also 92 IPR benefit. 15, para 15. We are of the considered view that if we accept the contention of revenue, then the alternative benefit of either exemption or deferment would result in differing benefits to the assessee who have opted for alternative benefit of exemption or deferment. The result emanating from accepting the revenue's contention is to make two exemptions, exemption or deferment, operate differently depending on their option. We are of the view that there exists no foundation for different treatment under the scheme itself, that is exemption or deferment. Therefore, in the absence of clear provision permitting different treatment to persons who opted for exemption deferment on a fair and harmonious interpretation of statute, such dichotomy has to be avoided. Accordingly, we allow this tax revision in favor of the assessee by holding that the tax liability petition has to be reassessed and determined afresh in accordance with provision of West Act, requiring computation of taxable turnover in accordance with law without referring to exemption under IPR 96. The recomputation will be done in terms of direction within a period of 3 months. Now, that's the only thing which I would like to point out for similarity. In this case, Louis packaging, Form 4 has been produced because Form 4, as my Lord's notes, supposing I want to avail concession otherwise, had I not given 1D92, which I had given under IPR 92, under the notification, I would have given Form 4. In that case, they have submitted Form 4. Here, I have not given Form 4. Form 4 is a mechanism, a self-certification. I have to give, this is not to be issued by department. I have to write that I have purchased goods by memo number so-and-so, dated so-and-so, for use in manufacturing or process. So, even in the other matter, the first judgment which I have given to Lordship Millers, that is direction strips, in that case also he has not given Form 4, and direction was similar to Ardek Engineering case, Gujarat High Court, and Louis packaging is also followed. My Lords may kindly see direction strips judgment at para 6, internal page 5. That is a case of so much revision on the very same issue, even if it was allowed Millers, and referring to Louis packaging of the full bench of the tribunal, then this reversal judgment of our High Court was not there. So referring to that, our tribunal, the commissioner has offered And now you will also get the petitioner there had approved the revisional authority assistant commissioner sex. So outline under Rule 80 of the OST rules, the revisional authority after scrutinizing the reassessment order passed by the assessing officer has passed the impugned order. Your lordship will find from page 6 the last paragraph of the order, Honorable Orissa
Louis Packaging.
Yes, Louis Packaging Limited versus state of essay number so and so. The main para 7, the main concern petition is that relying upon the judgment tribunal, the somewhat revision pursued initiated by the revisional authority, but now the same is reversed by this court in the case of Louis Packaging versus state of Orissa, reported in 2010 32 BST 481, wherein it has been observed as follows. Para 14, 15, 16, I have read before your lordship now. Now, in view of the matter and the basis on which the somewhat revision proceeding has been initiated by the revisional authority is now reversed by this court. Therefore, though there are some contention raised mainly on the ground that petitioner challenge order of assessment, and endeavor is made by the Lord Council for the opinion number 2 and 5 to justify in their counter affidavit trying to distinguish judgment where they have stated the order. Recording
Louis
all
Packaging
those.
was challenged by you? Was this Louis Packaging challenged by you?
In fact, in this case, we have no quarrel with the proposition laid down in that case, my lord. Here, my lord, what has happened by the time of this assessment year, the petitioner has already exhausted his exemption limit, and he was barely having 87,000 some odd to claim exemption. Now, for this year, he has the has at that point of time the option of giving a form 4 by giving a go by to this exemption, because he was only having 87,000 for that exemption in respect of that IPR, because he has already exhausted the rest. So he had the option of giving the form 4 at that point of time. Now he has not, admittedly, he has used that form ID exemption form, which he was not entitled to. That is why he is, the assessing authority has said that he has misutilized the form 1D, because he could not have utilized form 1D. He has the option of utilizing form 4. Now he has not given form 4. He has utilized form 1D. Now a submission is being made that I could have given form 4, or I am entitled to the concessional rate of tax had I given the form 4, my lord. And in the case, and in that case, my lord, the Louis Packaging form 4 was given, and as my learned senior is saying, in the first case, form 4 was given or not, that doesn't borne out from the judgment, my lord, whether form 4 was in fact given or not.
I was the counsel there also.
And in Louis Packaging specifically, my lord may turn to that Louis Packaging judgment, my lord.
Came in 2010.
Undisputed fact, that's at page 12 of the running page 12, paragraph 7. The undisputed facts are paragraph 7, E, my lord may see. The petitioner purchases raw materials either against form 4 under the OST Act or against you. So form 4 was given in that case. So here he had the option of giving form 4, but he had not given and utilized form 1D, which is an exemption form.
Louis Packaging came later. The matter in which your lordship is concerned, 97-98. By then, even full bench judgment was not. Full bench judgment
Rexon strips is later.
2010 only, yes.
No, Rexon strips is 2019, sir.
Sorry,
Louis
yes.
Package is 2009.
Correct. 2000, this matter, potent, yes, 98. Correct.
No. So I'm saying the tribunal did not have the benefit of Rexon.
Correct. That
or of what is the date of the order of the tribunal?
Date of order of tribunal is 12/4/2007.
So it did not have the benefit of either of these judgments.
Correct.
In fact, my lord, this judgment is not at the teeth. This judgment of the tribunal is not at the teeth of either of this judgment, because here is a case he has not given form 4 and he has given form 1D, knowing that I am not entitled to the exemption because I have already exhausted my limit. Because my lord, my lord, may placing the facts, my lord, paragraph page 26, my lord, may kindly see. Tribunal's judgment. There the fact has been substantially, my lord, placed. Page 26, 10 line from the top. It was eligible for
exemption of sales tax.
Exemption of sales tax on spare part, machinery, raw materials which had directly gone into composition of finished product and sale of finished product to the extent of 75% of the fixed capital investment for a period of 5 years from 6/1/1996. The fixed capital investment being 15,55,904 and the appellant having it availed itself rupees 10,79,821 by 31,397 had been found eligible for such benefit of rupees 87,107 within 97-98. 97-98 is the period under consideration. So he was only having 87,000 exemption limit, but till then he utilizes Form D to the extent of the whole 10 lakhs and all. And he doesn't give the Form 4.
That was the statutory form then.
Form 1D is for exemption, IPR. So he utilizes Form 1D.
That was the form applicable.
And not Form 4, the concessional rate of tax of 4% or 16%.
I could not have given then because the judgment had not come.
But judgment,
neither
judgment clarifies the law. Right, there he had the option of giving Form 4 and giving this 1D, not giving this 1D.
I could not have because 1D 92 was the statutory form, which is available to the assessor to furnish while purchasing raw material to avail exemption. Now the question is, what is the modality of calculation? 87,000 unspent amount which I have to avail, there is no quarrel over this. I have already consumed 10 lakhs. Even otherwise, my lord, this 10 lakh, had the judgment of today's been applicable to past periods, probably 10 lakhs would have been, which I have spent, might be reduced to even 2-3 lakhs. Maybe 7 lakhs might have been left for future use. But now the period has gone. I am not before lordship for past periods, so I cannot claim either. Those are gone. So only 87,000 is left. There is no quarrel over this. Now the question is, to get the benefit of 87,000, the unspent amount, what will be the modality? Whether the 16% notional tax, which the revenue claims to be payable, will be taken into consideration, or in terms of RDEC and our Louis packaging, the dealer which he would have otherwise been entitled to as a manufacturer to avail could have been the basis. And your lordship said, bereft of all this, whatever happened, forgetting a moment that he is eligible under IPR 92, he will be first treated to be a normal dealer, manufacturer, and the concession which would have been otherwise available will be made available. I think one thing your lordship, subject to Bernard objection, because it's a self-certification, the way in Louis packaging matter remitted back to the authority only for the purpose calculation, I may be permitted to give this form for there. And based on that,
difficulty would be,
that is the only, I think.
The difficulty would be Form 4 is.
The Form 4 is self-certification.
Self-certification. If it had been given at that point of time, my lord, then the department could have verified from the person to whom he is selling whether he utilizes it for this purpose or not, or whether it is sold inside the state or not. Now all these have gone.
1D 92 and Form 4, contents of tenor of both are same.
Here it is exempted, here it is 4%.
1D 92 I have given, there is no dispute. They are also agreeing to the same proposition that I have given 1D. 1D 92 is what? 1D 92, my lord, is a form in which I have certified that I am purchasing this from such and such dealer, right, memo number so and so, for the purpose of use in manufacture. And this is to be only reproduced in the form IV. Rather, 1D is a form which is issued by department members. They issue this. This is a printed form. Form 4 is a self-stationary, self-styled form, which is given by the manufacturer himself. This is a self-certification, which is also not to be furnished or filed. This is produced only. The language to produce. So let the assessee produce this only and certify this, so that he cannot buzz an inch that this is not my certification.
No, but you can exhaust only up to 87,107, correct?
That is the amount left.
So that he has no quarrel about his
utilization.
Exactly. That is the point. Whether it will be taxable at 16% or 4%. That's the question of law also.
Our High Court said 4%.
Without Form 4, it cannot be 4%. Now he is saying that now I will give Form 4 and let me be taxed at 4%.
It's only a modality of calculation. Eligibility is not an issue. Nor 87,000 also not an issue. That is also, I cannot have quarrel. Rather, I have lost precious periods earlier.
This is how we're not inclined.
But the other judgment which I have given, the first judgment,
packaging.
No, not ethics. Erection. Erection, my friend says that he is not aware, but that is also a case
where whether Form 4 has been given or not, that doesn't borne out from the order itself.
That can be verified also. But in any case, it's a question of only modality of calculation. Left to your lordship. But principle, if your lordship will follow the principle of Louis packaging, I think let them recalculate in terms of Lewis Millards, because the Lewis also.
No, but if you had produced the Form 4, they can. If you had not produced the Form 4, how can they?
Now your Lordship has to consider whether I could have furnished Form 4 in 97, 98. That your Lordship may also kindly consider. It could not have. Nobody could have, Millards. That is what you have Lordship decided.
No. So once there was a capping of 75%, you could not have produced anything, because you could not have produced the IPR form because of the capping, correct?
No, 1D92 I have given. 1D92, the statutory exempt form for availing exemption was furnished. That my friend will accept.
Yes, wrongly furnished. Improperly taken.
Not wrongly. At that
because
point of
87
time,
you are having, but you are taking credit of 10 lakhs.
At that point of time, that was the statutory form.
No, but you could not have produced. That's his point.
Could not have. That is my point.
I beg to differ.
No, it should not have. Actually, he's saying you should not have.
Could not have, because he could have produced Form 4, not Form 1D.
How can I furnish Form 4? Can I?
If you are having 87 only the exemption limit, then to the extent of 87,000, yes, you could have formed 1D.
Can I file Form 4 though in 97, 98? Can I?
Why not?
No, under the mechanism available, can I give Form 4? When the statutory form is 1D92.
1D for IPR exemption.
Not only me, all the IPR assesses, those who have to get exemption, were by then, because by then law was not clear. RDEC came later.
They could not avail one more concession if they were already given this concession. They were not aware that this concession was irrespective of that.
And your Lordship said that perception of the department is that you can't have
both the concessions.
Both. But your Lordship said that bereft of that, assuming that you are a normal registered dealer, to avail concession Millards, accordingly it can be computed, and from out of that amount, aggregation amount, you can avail as against certified eligible amount. That is the modality your Lordship will lay down now. And the form for which my friend is saying nobody could have. None of the dealer have furnished or could have.
Vis-a-vis IPR, now you have IPR to the extent of 87,000. No, now you could have said, no, as a normal dealer, I can produce the Form 4.
And
as a normal dealer. Now you choose to give Form 1D, which is not available.
And judgment came prior to this Lewis packaging. Both the tribunal and also our High Court.
Anyway, let us leave it be now. We'll uphold the order of the tribunal. I'll just dictate the order. It says, although the present revision petition was admitted by an order dated 17 July 2008, no question of law as such has been framed. So, nevertheless, the question that is urged by the SSC in the present revision petition and being considered with this court is as under. Now, take from page 13 of the revision petition. The background facts are that the petition is a small-scale industrial unit under the Industrial Policy Resolution (IPR) of 1992, engaged in the manufacturing of low-carbon ferromanganese, roasted manganese, and manganese products. Full stop. In terms of IPR 1992, and in terms of entry 43 bracket small a of the tax-free schedule, in terms of the notification issued by the Government of Orissa under Section 6 of the Orissa Sales Tax Act 1947 bracket OST Act, the petitioner is entitled to avail sales tax exemption both on purchase of raw material as well as on the sale of finished products for a period of 5 years in terms of the eligibility certificate issued by the competent authority. Full stop. However, this exemption is subject to a capping or ceiling of 75% of the fixed capital assets. Paragraph.
Fixed capital investment matter.
Fixed capital asset, it says here. Let's see the notification.
Fixed capital investment. FCI.
Fixed capital investment. All right. The petitioner states that it made a fixed capital investment of rupees 15,55,904 and therefore is entitled to avail exemption from payment of sales tax up to a maximum ceiling limit of 75% thereof, that is 1166,928, both towards purchase of raw materials, spare parts, machineries, as well as sale of finished products. Paragraph. For the assessment year, bracket AY, 1997-98, the petitioner claimed exemption in respect of purchase of manganese ore worth rupees 1157,823.62 on the strength of form 1-D bracket 92. Full stop. It also claimed exemption in respect of the sale of low carbon ferromanganese amounting to rupees 52,800. The assessing authority bracket AA observed that the petitioner had already availed exemption to the tune of rupees 1079,821 and therefore was eligible to avail sales tax exemption only to an extent of 87,107 for the AY 97-98. Consequently, the AA calculated the rate of sales tax on the purchase of manganese at 16% as per entry 69 of the schedule to the OST Act. The net result was the petitioner was held liable to pay sales tax on the purchase of raw materials to the extent of rupees 613,404.87 at the rate of 16%. And this amount was added to the taxable turnover of the petitioner. Full stop. Sales tax was also levied on the sales turnover of rupees 50,800. Full stop. The total tax demand by the assessment order dated 24th March 2001 was to the tune of 106,593. Paragraph. Agreed by the above order, the petitioner filed an appeal before the Assistant Commissioner of Sales Tax bracket ACST bracket Cuttack, who by an order dated 28 February 2002 confirmed the order of the AA. Full stop. Thereafter, the SSC went before the Orissa Sales Tax Tribunal bracket Tribunal with essay number 2289/2002-03. The order of the AA, the ACS and the ACST was concurred with by the tribunal by its order dated 12th April 2007. Paragraph. This court has heard the submissions of Mr. Jagavanthu Sahul, and its senior counsel appearing for the petitioner, and Mr. S.S. Padi, learned counsel appearing for the department. Mr. Sahu placed reliance on the decision of this court in Lewis Packaging Private Limited for the state of Orissa, 2010 32 VST 481 packet Orissa, where it was held that when the state government granted benefits under an IPR bracket, in that case it was IPR 1996 bracket, it must be presumed to be aware of the concessions otherwise available to the dealers under the OST Act, and that therefore the benefits under the IPR 96 open quotation was over and above what was provided under the OST Act, unquote. This decision was reiterated in the subsequent decision dated 20th March 2019 of this court in Writ Petition Civil 11513 of 2005, bracket Rexon Strips Limited versus State of Orissa, bracket. It is accordingly submitted that in the present case, the matter should be remanded to the tribunal to work out the exact concession that the petitioner would be able to avail vis-a-vis the balance sum of rupees 81
It is 87,107.
87,107. Mr. Sahu further added that at the time when the Form ID 92 was produced by the petitioner, it could not have produced a Form 4 for availing of the benefit of paying sales tax at 4%, since assessees like the petitioner were not aware of the correct legal position, as was explained by this court in Lewis Packaging Private Limited, Supra. He accordingly submitted that the petitioner should now be permitted to produce the Form 4 to avail the concessional rate of sales tax. In other words, the petitioner should be allowed to pay tax on the purchase of manganese to the extent of rupees 613,404.87 at 4% instead of 16%. Paragraph. Mr. S.S. Paddy Leonard, standing counsel of the department, on the other hand, contested the above propositions by pointing out that even the availing of the benefit on the strength of Form ID bracket 92 by the petitioner was impermissible, as it had already exhausted the ceiling limit to the extent of rupees 1079,821. Full stop. At a time it was entitled only to avail the balance amount of rupees 87,107 for the AY 9798. The petitioner chose to produce ID 92 in relation to the purchase of manganese ore worth rupees 1157,823.62. Full stop. He further pointed out that it would have been open to the petitioner to produce Form 4 for the balance sum of rupees 87,107, but it chose not to do so at the relevant point in time, and therefore the petitioner should not be permitted to do so at this stage. Paragraph. The above submissions have been considered. Full stop. While it is true that the legal position became clear after the decision of this court in Lewis Packaging Private Limited versus State of Orissa, Supra, with the court categorically holding that the benefits available to the dealers under the OST Act would be over and above. Sorry, the benefits available to the dealers under the IPR would be over and above what is provided in the OST Act, The fact remains that in the present case, the petitioner had already availed, for AY 9798 benefit under the IPR 92 to the extent of rupees 10, what was that?
10,79,821.
79,098. Yeah, 821, leaving a balance of rupees only 87,102. Full stop. It would not have been possible, therefore, for the petitioner to have filed a Form ID 92 for the entire sum of purchase of manganese ore as was done by the petitioner. 87107, right? There is merit in the contention of Mr. Padi that having not furnished a Form 4 at the relevant stage, the petitioner should not be permitted to do so at this stage. Stop. The court therefore is unable to find any error committed in the AA requiring the petitioner to pay sales tax at 16% on the balance purchase of manganese ore of the value of rupees 613,404.87. This 87,107 can be adjusted against that?
This is the tax amount, not the 87 is the balance tax eligible tax amount.
That's right. On that 16%, you can adjust this 87,107.
Yes, yes.
Yes,
Yes, my lord, that is
yes.
available to him. 87 can be deducted.
At the highest, the sum of rupees 87,107 can be adjusted against the tax liability so determined. Paragraph. Consequently, the question framed is answered against the SSC and in favor of the department. The revision petition is disposed of. We'll continue after lunch.
Weekly list passed over matter. Item number 21.
May I please, my lord? My lord, then the writ petition, my lord, the order of the ombudsman under annexure 9 is under challenge, my lord. My lord, the facts of the case is like this, my lord. My lord, this opposite party, my lord, OP number 2 is a consumer of electricity, my lord. He has installed his own transformer to avail power supply to his industry, my lord. And my lord, power supply was effected in December 2007. My lord, when bill was raised, my lord, as per the maximum demand indicator, whatever units he consumed, my lord, consumption is beyond the contract demand. Accordingly, bill was raised, imposing power factor penalty because it is the duty of the consumer to restrict the power factor within 0.9, my lord. Since the deviation is there, power factor penalty was imposed besides ODP, overdraft penalty also, my lord, in addition to the energy consumption charges. Then, my lord, he raised a objection. My lord, when on inspection, my lord, on 2008, inspection verification was conducted by the MRT squad and found that the my lord, the power consumption is beyond the permissible limit. And therefore, it was suggested that there is some defect in his transformer, to which the license has no role to play, my lord. Accordingly, my lord, the consumer replaced the transformer. That old transformer he has installed, he replaced it with another new one. Then, my lord, the defect was cured. Consumption came, normal consumption came, and my lord, protesting that bill which was raised, he went to the GRF. My lord, you may see the GRF order is, my lord, under annexure 4. Annexure 6, my lord.
Oh, 6, correct.
Annexure 6. My lord, GRF has said, my lord, I may place your lordship's attention at page 18, running page 18, from bottom to middle paragraph. It is the primary responsibility of the consumer to restrict the lagging kVAR drawal so as to keep the overdrawal power factor within 0.9. In this case, the consumer has failed to discharge his responsibility. It is further observed that after being advised, he has replaced the faulty transformer on 21/2008, and there was no discrepancies noticed after replacement of the defective transformer. As the consumer has failed to restrict the drawal lagging kVAR, he is likely to pay the kVAR drawal MD, maximum demand, as per the readings of the meter installed on the HT side of the transformer. The forum with the difference of opinion of the co-opted member, as appended below, to be communicated to all concerned, is satisfied on the version of the opposite parties that the meter installed in the secondary side, in the LT side, is an audit meter, and there was no defect in any meters installed in the consumer's premises. Then, my lord, finally, my lord, the co-opted member observed that my lord, in the last line of page 20, my lord, I am placing, as such, I am of the view that the corporate office OSCO Burla may make it convenient to have a proper study and find out a solution in which probability is to be considered to give solace to the consumer. That means he suggested that the corporate office of the licensee to consider the issue, my lord. Then, my lord, also simultaneously it was viewed that power factor penalty so imposed may be withdrawn, overdrawn charges may be withdrawn. These two aspects to be withdrawn, and the consumer is liable to pay the energy charges, including the demand charges. My lord, disputing that, my lord, the consumer moved to the ombudsman, my lord. My lord, what the ombudsman did, my lord, the order is under challenge. My lord, let me see, the ombudsman has said, my lord, operative portion I am reading at page 45, my lord, just last paragraph above 2 lines. At the same time, the onus also lies on the consumer to install the correct transformer manufactured with the design parameters. It is his installation. He cannot surpass his own responsibility to install the right transformer under such state of affairs. While suspecting defects with the old transformer as well as the old cities, I am of the opinion that let both the parties share financial impact caused through some convert grounds, not being intention of any of them. Against the maximum demand of charging for the months of 12
2007 and 1st January 2008. The petition is payable for that is MD 69.3 and 769.5 kVA respectively at the rate of 200 per kVA along with over trial charges, as the licensee is also contributing high negligence in bypassing legal provisions before commencement of supply. The petitioner is not required to pay the power factor penalty. The delay payment surcharge is also waived out. To balance justice, the petitioner is allowed to avail above relief. Due to peculiarity of the case, it is decided to share the financial burden by both the parties. My submission is the license has no fault at all attributed to the transformer. Why license will bear the loss as alleged by the petitioner consumer to have sustained? It is his fault, and it is the categorically held that the fault is with the consumer because the transformer belongs to him, become out of order, or that consumes more power because of some technicalities. It consumes more power. Since power supply has been utilized by consumed by the transformer, defective transformer, or the consumer, licensee is to get back its dues. And since the meters are not, 2 meters are installed, one is challenge meter, another is consumer's meter, and it is categorically found that the meter is not defective to record the actual consumption consumed by the installation of the consumer. This is my whole submission. The ombudsman order is without any basis. He has said that the negligence in bypassing legal provisions. What legal provisions the license has bypassed? The ombudsman has not pointed out that. Only by to weigh the loss in between them, this has been said, which is not legally fair and proper. And the consumer is to bear the entire charges, as per actual unit.
This is a 2011 order. There is no stay granted by this court.
The OP appeared, and it has been adjourned to some other date, That is why, have
you implemented the order or you not?
If your lordship, did not grant stay, that will not mean that I have no case, I have a very good case,
So it means deemed stay. If we did not grant stay, it is a deemed stay, is it?
No, I am not saying that deemed stay, We
have
not
implemented the order or have not implemented the order?
By virtue of pendence of this case, we have not taken any step for realization of our dues,
Which means you have given yourself a stay.
We have not taken any step against the consumer for realization of the dues, even if no stay is granted, But we have to get back our dues,
You have to share the burden. Where's the question of getting back? You have to share the burden. You have filed a petition here saying, don't make me share the burden.
No, we have not said the share.
No, you are not aggrieved by the impugned order?
Yes,
How are you aggrieved?
Because the ombudsman has said that we are liable.
Which means you have to pay something or you don't have to pay anything?
I am the license for the license,
Sir, by the impugned order, are you required to pay anything or nothing?
No, we have to pay our dues.
So have you paid your dues or not is the question.
From the consumer, we have to get our dues,
What is the calculation? What have you worked out?
That bill was raised,
Don't ask us to sit here and calculate. What have you calculated? What have you calculated? Who owes whom how much?
The bill was served to the consumer, that I am to find it, The consumption is, MD recording is 690.3 kVA.
So we sit here and calculate, sir? You want us to sit here and calculate?
No,
When I'm asking you a specific question, what is the amount you have to pay? What is the amount the consumer has to pay? Plus, minus, who has to pay whom, how much?
The consumer will pay to us, to the licensee. That bill,
Sir, I'm finding the whole approach so casual. You do not have a stay from this court. You do not know what the impugned order entails in terms of rupees naya paise.
The bill, so far bill is concerned, I will, give me some time, tomorrow.
Sir, it is only a 11-year-old matter. What is your view, sir? It is only a 11-year-old matter. We'll give you more and more time.
No, I have not taken time, First time it has come.
Oh, so you are entitled to time.
No.
You are by matter of right, you are entitled to time. If you do not answer our questions, we have to give you time.
To meet my lord's query,
So mistake is ours, right?
No,
mistake is mine and asking you a question.
No, certainly.
You are not committing any mistake. Only the judge is committing the mistake of asking you a question.
Milord, that bill, Milord, yes, Milord, page, let's have a glance to page 17. The bill amount is 3,40,000.
What do you have to pay them, sir? If you say I have to pay nothing, we'll dismiss the petition now because you have to pay nothing.
Milord, this is the due bill raised to the consumer. Consumer is to pay this amount, Milord, to the licensee.
If you, sir, if under this order, you have to pay nothing to the consumer, we will dismiss the petition. We'll simply record a statement that according to you, in terms of the impugned order, there is no liability on the petitioner. We'll simply dismiss the petition.
No, Ombudsman has not said so. Ombudsman has said, Milord, that it is to be shared by both the parties. Milord.
So you're not answering any question. You're really now testing our patience.
Milord,
you're not prepared to answer any question.
Milord, this is the order of Ombudsman, Milord. The petitioner is payable this much of KVA, respectively, the amount of which is, Milord, 3,40,000. In addition to that, Milord, that is overdraw penalty and power factor penalty, Milord. That amount, power factor penalty, I cannot say.
The petitioner is unable to inform the court what amount the petitioner is supposed to pay the consumer in terms of the impugned order of the Ombudsman.
Well, that is
so
only
despite repeated queries, he has no clear answer whether there is any grievance at all of the petitioner as a result of the impugned order of the Ombudsman. The court is therefore unable to appreciate why the petitioner has challenged the impugned order of the Ombudsman, if in fact it is not inconvenienced by such order. The petition is accordingly dismissed.
Milord, the power factor penalty, Lordship may say that the power factor penalty and overall penalty may be exempted, Milord, as directed by the Ombudsman, Milord.
Yes,
leaving these two aspects, Milord, the rest part amount, let him pay, Milord.
Pass over matter item 27.
Milord, I don't my prayer, Milord. That power factor
Sir,
penalty.
the day you decide when to answer our questions, then we listen to you. Accordingly, you are not obliged to answer any question that the court asks you.
Milord, that power factor penalty, that overall penalty.
We'll consider the day you have answers to the questions we're asking you, we'll consider everything.
That is a calculation, Milord. That is not within my knowledge, Milord.
Yes. Only two judges of the High Court have to sit and make all your calculations. Yes.
Item 27. Pass over.
Milord, consider that.
Who's in item 27?
Milord, myself is on 27.
I am for the OP number 2, my lord.
Milord, I have prepared a small date chart, Milord.
One document also.
Milord, this in this writ petition, Milord, the order of Ombudsman is under challenge, Milord. Milord, the case is like this. Milord, this OP is a consumer 10 years back, Milord. 10 to 12 years back, Milord. Milord, power supply was under disconnection, Milord. Milord, what happened? One Makhanlal Agrawal was the MD of the rice mill that is called Utkal Lakshmi Rice Mill at Bolangir, Milord. Milord, he resigned on 5/9/2003. Milord, from the post of MD, Milord. And Milord, on 7/11/2003, another man named Narendra Kumar Sahu was appointed as MD. And another, Harinarayan Jain, was appointed as director of Mr. Utkal Lakshmi Rice Mill, Milord. Milord, this Makhanlal Agrawal, starting from 8/11/2003 till 2006 and Milord 2010, Milord, he filed a number of cases before the GRF High Court, before the Ombudsman, Milord, identifying himself, swearing false affidavit in the capacity of MD, Milord. When the matter was detected, because the new MD wrote a letter to the complain their distribution licensee that I am no way connected with these legal proceedings. If you are making any negotiation with or making any litigation, fighting out any litigation with this then MD who has nothing to say, I will not be held responsible. Then, my lord, before the ombudsman of ORC Bhubaneswar, my lord, the case which was pending there, my lord, that is CR case number 5/10, my lord, that was ultimately rejected on the ground that this fellow Makhanlal Agrawala, who has filed false affidavits in all the proceedings, my lord, the case is not maintainable, and it was accordingly rejected, my lord. And subsequently thereafter, my lord, in December 2010, again after a long lapse of 7 years, my lord, another complaint case was filed before the GRF Balangir, that is complaint case number 575 of 2010. And my lord, by the new MD through that very same person, my lord, who has committed and a fraud and a mischief by representing himself as the MD, though he has resigned since 2003, my lord, this case was finally, my lord, dropped because of non-appearance of the complainant, and it was observed that the Makhanlal Agrawala, whose appearance was declared as unauthorized, he cannot pursue the matter, my lord. Subsequent thereafter, my lord, he filed the CR case number before the ombudsman, that is CR case number 2 of 11, directing the GRF Balangir to dispose of the complaint case 575/2010 afresh, allowing Sri Makhanlal Agrawala to represent the complainant, my lord. Against the said order, my lord, the present representation case, present writ petition has been filed, my lord. My lord, my submission is said Makhanlal Agrawala had no authority to file any case, my lord, which was rejected by the ombudsman. And again, my lord, on his appearance, my lord, the case was taken over by the forum, and the forum has rejected the same. And the ombudsman has said, my lord, let me see the last part of the order, my lord. Hence, in view of the above changed circumstances, for the ends of justice, it would be proper to allow Sri Makhanlal Agrawala to represent the complainant. In view of the matter, while setting aside the impugned order dated 7/1/2011, I direct the GRF Balangir to dispose of the case after hearing both the parties on merit, wherein the complainant may opt to appear personally or through any other person as his authorized representative. My lord, what I submit, my lord, when while passing this order, the ombudsman has not observed in mind, my lord, the relationship between the consumer and a licensee, my lord, and also the limitation aspect, including the jurisdiction of the forum to deal with the complaint, my lord. My lord, the GRF is the creature of statute under section 42(5) to hear the dispute between the licensee and a consumer. My lord, here, my lord, there is no relationship with the consumer with the present petitioner as a licensee since last 10 years back, my lord. Because power supply was disconnected, and after disconnection of power supply, there was termination of agreement after 2 months thereafter, my lord. You lords may see the definition of a consumer, my lord. There is in section 215, consumer means any person who is supplied with electricity for his own use by the licensee or the government or by any other person engaged in the business for supplying electricity to the public under this act, my lord. So far this case is concerned, my lord, there was no relationship last 10 to 12 years, my lord. The unit was defunct and there is no existence of that unit, my lord. And moreover, there is no relation of the consumer and licensee. So the GRF as well as the ombudsman has no right to entertain a complaint from a person who is neither the consumer nor, my lord, he has any relationship with the that industry Utkal Lakshmi rice mill, my lord, to invoke the power of the ombudsman and also GRF, my lord. My lord, in one hand, my lord, the subsequent MD Narendra Sahu, he is claiming that I am the MD, no case should be fight out at his instance, my lord. And my lord, in other hand, my lord, this Makhanlal Agrawala is fighting out the litigation as a representative in the latter stage, my lord. Who has no jurisdiction to entertain the same. The forum, instead of deciding this, my lord, whether the complaint is maintainable or not, whether he is a consumer or not, whether the grievance is subsisting or not, my lord, the time-barred claim has been entertained and the ombudsman has remitted the matter again to the JRF Balangir for adjudication, my lord.
Yes, what do you say?
My lord, the letter of resignation and thereafter the letter of the managing director, my lord, which my respected senior is referring to, is general letter. But I have, my lord, just passed on the letter, my lord, the special resolution of the board of director, in which Makhanlal Agrawal resolution of board of director dated 15/12/2020, wherein Makhanlal Agrawala has been is the authorized representative to look after this case, my lord. In this particular case, your lordship may kindly turn to annexure 5, page 19, which is the impugned order before your lordship, and the land ombudsman has taken care of this fact, my lord. Order person, your lordship may kindly see, my lord. Order person, my lord, second paragraph. It is revealed to refer to the resolutions of board of directors dated 15/12/2010 of Messrs. Utkal Lakshmi Rice Mill Private Limited, annexure 2, which is as follows: to look after the litigation going on with regard to the bill revision and penal bill with Wesco, for the reason that he is well versed and has complete knowledge of the case and day-to-day happening of the matter. Result further that he is also authorized to sign petition, file affidavit or application as authorized signatory of the company.
So what is the complaint about?
My lord, the complaint about is the bill of the company, my lord. We
When was the bill raised, sir? Which bill? Which bill are you challenging?
My lord,
Come to the GRF order, we'll know that.
my lord. GRF order is, my lord, at annexure 2 series, my lord.
Which bill are you challenging, sir?
It was only on technical ground, it was dismissed, my lord.
What is your challenge, sir? Which bill are you challenging? What is the date of the bill?
Said bill is not with me, my lord.
You should know what you're challenging at least, sir.
My lord. Because as it is only a remand order, my lord, by the
What are you challenging? What are they remanding? He's pleased that all of this is heavy time barred. What is your answer to that?
My lord, because this honorable court, my lord, passed interim order not to take up the hearing. Therefore, my lord, hearing was not taken.
Sir, what? That is not the question that I'm asking you.
My lord, my lord.
Your original complaint before the GRF, what was that complaint about?
The complaint is about, my lord, the disputed bill.
Which bill, sir? Do you have a copy of the complaint filed by him?
My lord.
You have a copy of the complaint. Tell us which date bill that is. Which
My
bill
lord,
is being
my
challenged?
lord, that relates to reduction of a contract demand pertaining to the year prior to 2003, my lord.
Don't say prior to, sir. Tell us which bill.
My lord, my lord, my lord, this is the complaint, my lord, filed him before the GRF, my lord. My lord, may I place this, my lord? My lord, the complaint relates to, my lord, My lord, he has his prayer is just like this, my lord.
My lord, this is the complaint petition.
You read it yourself, sir, and tell us what is written in that. What is the prayer?
Shall I place?
Prayer, yeah.
Yes, it is therefore humbly prayed before this forum that the opposite parties be directed to submit their case for hearing of the matter. After hearing the parties, this honorable forum may allow the reduction of a contra demand of the petitioner from 113 kVA to 78.92 kVA from the date of application. My lord, date of application not known, my lord. Revision of energy bill from the date of a load reduction. Waiver of a penal bill dated 11/5/2001
okay.
for rupees 7,45,593. My lord, in 2010 a complaint is filed for waiving out penal bill which was imposed in 2001, and a subsequent the revised penal bill amount
What
of
is the limitation for this? What is the limitation under the law?
Limitation is, my lord, within, my lord, of 15 days, my lord, he has to raise the grievance before the licensee, my lord.
Under which provision, sir?
My lord, that is under the GRF and Ombudsman regulation, my lord. If his grievance will not be resolved within 15 days, my lord, then he has to move to the Ombudsman, my lord, GRF, my lord.
Within what time?
My lord, 15 days thereafter, from
What
the
is the
date,
provision, sir?
my lord.
Limitation can't be.
My lord, I
It
am
has to be
bringing-
some provision.
My lord.
Just give me the Electricity Act.
My lord, so far disputed bill is concerned, my lord. The as per regulation 93, my lord, 91, in the event of any dispute in the billed amount, the consumer may lodge a complaint before the designated authority as determined by the licensee and pay the average last 6 months consumption or the billed amount whichever is less within due date pending settlement of the dispute. The licensee shall resolve the dispute of the communicate its result to the consumer within a maximum period of 1 month as per regulation 92. If the licensee finds the bill to be erroneous, a revised bill shall be furnished to the consumer indicating the revised due date. Excess amount paid by the consumer shall be refunded by way of adjustment in the subsequent bill. Such excess amount shall be refunded together with interest at the rate of 1%.
So what is the limitation for filing this complaint, sir? Is that only electricity cases there and this fresh complaint that was filed in 2010, do you have a copy of that complaint?
Miller?
You have given a list of dates.
Yes.
In which in page 3, you
Yes,
have your
yes.
list of dates?
Yes, Miller.
In page 3,
Fresh complaint.
December 2010.
Yes, 2010.
You are saying a fresh complaint 575 was filed.
Yes.
Do you have a copy of that complaint?
Yes, Miller. That I was placing, Miller. This complaint, Miller. This prayer is this, which I.
So this is the fresh complaint.
Yes, Miller.
What about the first complaint?
First complaint, Miller. I am to find out that.
23 of 2005.
Yes, Miller. My lord, this complaint, my lord, we had applied for reduction of our contract demand to the executive engineer, BD Bolangiri, along with the following documents, a copy of which is enclosed here with, my lord. Application. Then on this, we have asked to deposit rupees 1,000 by the executive engineer, Gridco Bolangir, by his letter number 26/3/1997 towards the processing fee for road reduction, and accordingly we deposited the same amount by the money receipt number so and so.
Tell us what the prayer there is. What is exactly the release of?
My lord, the prayer is, my lord, the penal bill should be withdrawn totally, and the payment made against should also be refunded immediately. The excess amount already paid towards energy bill and the penal bill may kindly be refunded to us immediately.
Which penal bill are they talking about?
Against the penal bill only, my lord.
Of which date, sir?
Sir, in 2001, my lord. As revealed from that other complaint.
Both the complaints, sir. It was both the complaints.
My lords.
2005 and 2010.
Yes, yes. Time barred.
Claims are all time barred.
Yes, madam. Complaint
No
is
point
already
in sending it back.
complaint is already time barred, madam.
The challenge of the present petition is to an order dated 26th March 2011, passed by the Ombudsman, Orissa Electricity Regulatory Commission, Bhubaneswar, remanding
Complaint case number 575 by 10.
forum case number. Sorry.
Plot 575 by 10.
Remanding the complaint case number 575 2010 to the Grievance Redressal Forum (GRF) Bolangir. Paragraph. This petition has a long history. Stop. The opposite party, number 2, Utkal Lakshmi Rice Mill Private Limited.
Lord, pardon me, Lord. Lord, that time limit your Lordship asking, that is 15 days. That is provided in OERC, Grievance Redressal Forum, Ombudsman Regulation 2004, Clause 4. My Lord, a complainant agreed by any action or lack of action of the engineer under the OERC Distribution Condition Supply Code 2004 may file a complaint before the forum for redressal of his grievance after expiring of 15 days from the date from the time limit fixed by the licensee in their complaint handling procedure. Their complaints, their said complaints shall be in writing and from the forum may not insist any format for such.
Limitation means before, sir, not after. Limitations means by within which time do you have to file. This only says when you can file, you have to file after 15 days. This is not limitation provision. Had a contracted demand of 113.33 kVA. Stop. By letter dated 26 March 1997, opposite party number 2. Sorry, by letter dated 11th March 1997, opposite party number 2 requested the executive engineer, Vesco Balangir, for a fresh agreement in medium industry class, since one dryer and one parboiling unit of the mill of the rice mill had been closed. Full stop. In terms of a joint verification report of 29th April 1997, the load was found to be 78.62 kW. As the load reduction was not effected, opposite party number 2 approached the Bijli Adalat in 2000. Full stop. By an order dated 29th September 2000, the Adalat directed Wesco to reconnect the line, which had been disconnected on 30th August 2000 for non-payment of arrears, subject to payment of 30% of the arrears. Since in the joint verification done on 11/10/2000, the load was found to be 95.80 kW. It was recommended by the superintending engineer that it would be proper to reduce the load to 95.80 kW. Paragraph. On 17th April 2001, a meter test was conducted and there was tampering found of one of the seals. A penalty bill of rupees 7,594 was served on the consumer. When the disputes arising out of the penalty bills were unable to be resolved, opposite party number 2 approached the GRF with case number 16-05-06. In an order dated 11th November 2005, the GRF noted that the complainant had agreed to settle the penal bill at a reduced amount of rupees 1,80,000. On 26th October 2002, it ordered that load reduction to 78.62 kW will be permitted with effect from 1st April 97, semicolon, since additional load was detected on 11/10/2000. A penal bill for the additional load shall be levied and the contract demand would be enhanced to 95.80 kW with effect from 11/10/2000. The revised bill from 1497 to October 2005 would be served on the consumer within 1 month. Paragraph. What is that list of dates? It appears that during this time, opposite party number 2 was represented by Sri Makanlal Agarwal, who was described as its managing director (MD). as its director. Sorry. Full stop. According to the petitioner, despite Mr. Agarwal having resigned, as managing director on 5th September 2003, he continued representing the opposite party number 2 in all litigations involving it, even thereafter. A consolidated petition, being CR case number 5 of 2010, was filed before the Ombudsman on 19th April 2010. On 25th August 2010, the said case was rejected by the Ombudsman. It was held that since Mr. Agarwal had no authority to represent opposite party number 2, the case was not being entertained on merits. Full stop. It was, however, left open to opposite party number 2 to raise a dispute afresh before the GRF, open quotation, in lawful and regular manner, unquote. It appears that in December 2010, a fresh complaint case 575 of 2010 was filed before the GRF, again through Shri Makanlal Agarwal, and again questioning the same penal bill. Full stop. The GRF rejected this complaint case on 7th January 2011 on account of non-appearance of the complainant, as well as lack of authority of Mr. Agarwal. Full stop. Against this order, opposite party number 2 approached the Ombudsman for relief. Full stop. The said CR case number 2 of 2011 has been disposed of by the impugned order dated 26 March 2011, remanding complaint case number 575 of 2010 to the GRF for a fresh decision. Paragraph. The grievance of the present petitioner, that is Vesco, is that the remand of the case has been made unmindful of the fact that on the same issue, an earlier petition had already been rejected by the Ombudsman. And without going into the question of limitation and maintainability of the complaint or jurisdiction of the GRF, the case had been remanded to it. Paragraph. This court has heard the submissions of, it may be noted here that while directing notice to issue in the present petition on 30th May 2011, this court stayed further proceedings in complaint case number 575 2010 before the GRF Bolangir. Despite notice being issued to it, opposite party number 2 has till date not filed any reply. Full stop. Having heard learned counsel of the parties, the court is of the view that one of the main prayers that the complaint before the GRF Bolangir was badly time barred. Full stop. It pertained to a penal bill dated 11th May 2001 in the sum of rupees 747593. Full stop. Even the initial challenge of the said bill before the GRF, which was raised in 2005. Had been rejected by the GRF, which rejection had been upheld. No, had been disposed of with the GRF in the manner indicated here and before. Full stop. In the first round itself, the Ombudsman had rejected the case filed by the opposite party number 2. Full stop. Consequently, the Ombudsman in the second round could not have simply remanded the case to the GRF without examining if the complaint itself on the same cause of action was maintainable for the second time before the GRF. Full stop. Considering that what is an issue is a bill of 2001, clearly a complaint filed in 2010 would be time barred. Stop. This basic issue was lost sight of by the Ombudsman. And in the impugned order, it has mechanically remanded the matter to the GRF for a fresh decision. Paragraph. The court consequently is satisfied that the impugned order is unsustainable in law and it is hereby set aside. The petition is allowed in the above terms, no order is to cause.
Yeah. Milord, I mean, pardon, Milord. Item 21, Milord, the adverse against me, Milord, as a lawyer, Milord.
It's all right, please. We are done with that all.
I will satisfy your lordship, may call it tomorrow.
No, sorry. Yes.
Supplementary list passed over matter item number 5.
May I please, nurse? Well, Lord, I'm in the virtual mode.
Yes.
Lord, these 5, 6, and 7 are similar matters, identical issue.
Yes.
I'm questioning here the rule 4.1 of the placement rule 2014. I'll kindly turn to, that is annexure 3, the gazette notification of the state government, 4th June 2014. Here is the case, my lord. The state government for the first time brought in a scheme allowing the lecturer group A scale and reader state scale to the employees who are in receipt of the block granting aid. May I continue, ma'am?
Yes, please.
Can you turn to the annexure 3, page 23, my lord, which is under challenge. That rule 4.1, I am questioning the validity of this same. Kindly see. This is the placement rule of 2014, wherein the eligibility criteria has been fixed for one. There is only one cadre, that is called the cadre of lecturers in aided colleges. Now, while introducing this placement rule, in order to bring the teachers into a, like my lord, that career advancement scheme, lecturer group A scale after 8 years and reader scale after 10 years. This is understood. But while allowing this lecturer group A scale to the lecturers, there is a discrimination, my lord. They have categorized, subcategorized 3 categories of lecturers. May I read, my lord, plus 4.1?
Yes.
Page 24. Eligibility criteria for placement. 1. In order to be eligible for placement to the grade of lecturer group A scale of pay under Rule 9, a lecturer as covered under Rule 3 must have 1. Completed 8 years of service as such from the approved date of joining in case of SSB, State Selection Board sponsored lecturers, public junior lecturers. B, completed at least 8 years of service from the date of receiving full grantee in the post of lecturer in case of appointment by the management. Then C, completed at least 8 years of service from the date of eligibility for full grantee in case of lecturers whose service has been validated under the Validation Act. Validation Act has been clarified further, my lord, in a circular. There is Validation Act 89 and Validation Act 1990. My lord, I will come to later. My lord, the lecturers are in the common cadre, my lord. But now, while allowing this career advancement benefit, they have now allowed those who have been sponsored by the selection board. They will get immediately after the date of joining 8 years, they will come into the benefit. Whereas a lecturer who is appointed by the management, he will come after 17 years. And the lecturers who has come through this Validation Act, he will get, it is depending upon the date of eligibility of his appointment. But the lecturers Validation Act 98 says all will come into the grantee for from 17/10/98. That is the date on which this Lecturers Validation Act came into existence. Well, this is my response submission is this is discriminated. For the reason, my lord, in a private or unaided institution, management is the appointing authority. But there are three mode of selection of lecturers into such unaided institutions. When the institution was established, the private management is in charge of the institution, and they have the right to appoint a person on their own selection. But when the second mode of is, my lord, if an institution became aided, then the selection will be made by the State Selection Board. That is an agency created by the state government for recruitment of lecturers to the aided colleges. Because after this institution become aided, the governing body seizes its power to select candidates, but the appointing authority ultimately is the management, governing body. So third mode is if an institution is aided, but selection board candidate could not come within time because it is to be done by agency. Then, my lord, the management has been given power under Rule 8 to appoint its staff on ad hoc basis, fill up those posts on ad hoc basis. But because some persons were continued for a pretty long time, government has brought in this Lecturers Validation Act. Initially, my lord, it was in 81, thereafter 1989. Last Validation Act was of 1998. So, my lord, all these persons, those are appointed by the management after the institution became aided, they have also been validated and deemed to be regular employee of the institution. But while granting this benefit, now there is a discrimination. They are created a subgroup, 3 groups between one group of lecturers. When these SSB candidates are allowed, on the date of joining, they will get the benefit of senior lecturer. Whereas a lecturer appointed by the management, when the institution was not aided, because here, my lord, I will pose here, the institution when unaided, the modality of payment of grantee depend upon the different scheme formulated by the government at time to time, my lord. Last grantee order 1994 was there. This present petitioner was approved under this grantee order 1994. The provision was, my lord, a lecturers appointed by the management, duly appointed by the management, I will say, my lord, on institution being aided, they will be approved and paid grantee after 5 years 1/3, 7 years 2/3, and 9 years full salary cost. But if the institution is situated, it further stipulated in the grantee order, if they are appointed in an educational backward district, like that of the present petitioner here in this case, because there are certain institutions which are situated in the educational backward district, their mode of payment will be 1/3 after 3 years.
So you have not filed counter at all in
No,
this?
this is the first time.
No, they have not filed any counter.
It is first time it has come. Not sure.
So
Kindly
it has
see.
come before the single bench, thereafter
This is a rule of 2014 and a clarification of 2015 they are challenging in the year 2016, my lord. And all of the 3 petitioners, they have reached the age of superannuation, my lord. All are above 60 years. So Lordship generally is keeping it open to the people who are still continuing to challenge it.
We are the beneficiary. We will get it earlier. If it will, my case will be considered by my lord, then I will get the financial benefit.
No, my pension one of the petitioner, my lord, one of the petitioner is now 62-year-old. Another petitioner is 64-year-old. Yes. Only one of the petitioner is 60-year-old now. That is also age of superannuation is already reached. Lordship is generally keeping it open to people who are still continuing in service to challenge it in case they are aggrieved, my lord.
It is a financial benefit. We have come in time. So we will get the benefit in pension also. Let my friend file a counter, my lord. Or my lord, I may be permitted to place the entire provisions of law.
No, he is not. If it is a violation, I mean, if you're challenging the virus, they have to file a reply.
My lord, let my friend file.
All right. You say no formal notice has been issued.
No, my lord.
It was
No.
once listed before the Honorable Single Judge who has directed it to the District Class.
All right. Notice, Mr. He accepts notice on behalf of 1 and 2. Notice to opposite party number 3 by registered speed post returnable. On the next date, replies we filed within 8 weeks rejoined up for the next date. Just on 22nd August.
Obliged.
Item 6 and 7.
Same.
6 and 7, my lord. Same, my lord.
Item number 14. Pastor matter, item number 14. Supplementary list.
None appears to since number.
Pastor matter, item number 33. Supplementary list.
(33, 34, and 35 together.
Yes. May it please your lordship.
What's the delay, sir?
Delay, my lord, that the chief about 1 year, 373 days, because that is government policy matter and the member secretary was on leave. So taking permission for filing this appeal before your lordship, after the order of the Orissa Income Appellate Tribunal, delay become delay.
No. What is it? The secretary, which secretary has to give permission?
Para two of the, that is, it is humbly submitted the limitation with sir. The officials of the whole medical institution engaged before the Medical Council of India as well as the Health Family Welfare Department, Orissa, for renewal permission of admission of a batch of MBBS students. That is medical. That is.
What has that to do with filing this appeal, sir? Nothing. What has that to do with this appeal? And not 1 year, sir. 379 days is too much.
370
No.
days, 79 days.
This is not a valid explanation, sir. You see, IA number 48 of 2018, there is a delay of 379 days in filing this appeal. The explanation offered, para 2 of this application, is that the officials of the institution got engaged in the Medical Council of India. Before the Medical Council of India, renewal of permission for admission of the third batch of MBBS students for the academic year 2018-19. Full stop. This by no means could have prevented the appellant from preparing and filing the present appeal within time. The explanation offered is not convincing at all. Consequently, the court is not inclined to condone the delay in filing the
Transfer
appeal.
of the superintendent.
IA number 48 of 2018 is accordingly dismissed. Consequently, ITA 161 of 2018 is dismissed. Likewise, in each of the matters.
34 and 35.
Yeah.
Same matters.
All right.
My lord, I am appealing the department.
All right, sir. All right. Right.
Hearing matter. For hearing item number 37.
My lord, if somebody, some amount is deposited towards the welfare fund of the bar, the delay may kind
No, not 379 days.
because it is a beneficial, it was done by the Orissa Legislative Assembly only to protect the poor patients from the process of the nursing home people and some on a payment token money who has to get the treatment.
That's
it is
all.
only for beneficial.
Sorry, you're not inclined. Yes.
37.
May I please?
Yes.
Yes, this is an application under section 24(2) of the Orissa Sales Tax Act. And the questions of law, my lord, is at page 5. The lordship's brief minutes.
Yes.
The first question is whether on the facts and circumstances of the case, the Honorable Sales Tax Tribunal, there's some typographical mistake, my lord. I'll just take your lordships to page 42, my lords. Page 42, the questions are. What you've got it? Page 42, annexure 5 minutes.
Yes.
Whether on the facts and in the circumstances of the case, the Honorable Sales Tax Tribunal is justified to treat the sale of paper to manufacturing registered dealers against declaration in Form 1A out of the paper purchased by the furnishing declaration in Form 34 inside the state of Orissa in contravention appended to Section 5.2, it should be 5.2A82 of the OST Act. Whether the Honorable Sales Tax Tribunal is justified not to consider Sections 6 and 7 read with Section 4 of the Odisha Sales Tax Act. Whether the Honorable Sales Tax Tribunal is justified to sustain the order of assessment passed under the Odisha Additional Sales Tax Act, for which no separate notice has been issued under the Odisha Additional Sales Tax Act, as Odisha Additional Sales Tax Act being an independent statute as held by the Apex Court. Whether on the facts and in the circumstances of the case, the Honorable Sales Tax Tribunal is justified to confirm the orders of the assessment passed under the Odisha Additional Sales Tax Act 1975, wherein the Additional Sales Tax Act has been levied on the amount of contravention under Section 5.2A82 of the Act of the OST Act 1947 and do not form a part of the gross turnover under the OST Act 1947. Here the facts of the case, my lord, is the petitioner purchased paper, my lords, by using Form 4, my lords. And the allegation is that once you purchase these papers on the strength of Form 1.4, you cannot sell it at a concessional rate of tax, my lords. So at this juncture, my lords, may just place Form 34, my lords. Lordship may kindly take up the OST Act, my lords, for a moment, please.
Yes. Counterfoil, duplicate, original.
Malas. Your Lordship may take up any one. I'll just take the second part of it. To so and so, so and so, so and so, certified so and so. That will not be very relevant.
Meant for
and an amount of rupees so and so. Your Lordship got it?
Yes, are meant for the
purpose of resale in Odisha in a manner that such resale shall be subject to levy of tax under this Act and are covered by our registration certificate number so and so issued under the Odisha Sales Tax Act 1947. Now, this bracketed portion, in a manner that such resale shall be subject to levy of tax under this Act, was brought into the form 26th of April 1978. Originally, it was not there. So this condition, my lord, was brought into effect with effect on 26th of April 1978.
Yes.
Then, if your lordship, this Form 1A. Form 1A, my lord, is a form which was given to the IPR exempted units of 1980, my lords. And the relevant entry, my lord, of the exempted list is entry 26A of the exempted list, my lords. And this exemption, my lord, is under Section 6. Your lordship would just see that it begins with in exercise of powers conferred under Section 6 of the Odisha Sales Tax Act. So this exemption, entry 26A, capital A, my lords. May I please pass on my book notes?
The rate.
26 capital A.
1 minute. Do you have the same book, this one or no?
No, no, I have a different book. No, may I just pass on the books for your lordship's time
Better we
convenience?
get it here. 1 minute.
Not there's a first point tax. Sir, put it this.
26A is omitted now.
Sorry, Manoj?
Yes, my lord. There in
It's
the
omitted
new
from
26A.
1899.
At the relevant point of time, 26A was there, my lords.
So here
That
it's
was
omitted.
relating to IPR 1980. May I just pass on that book, my book notes? Figure 9.
This is the page. The page numbers are not very same.
Lordship,
Get this is rate chart. Same. Rate chart.
Lordship
No
may
page
take up
number.
my book. 26A. This was for IPR 1980, my lords.
Yes.
If your lordship would appreciate that on the left-hand side, your lordship would say that for purchases of raw materials, for packing materials, and your lordship may read down, my lord, then your lordship may come to the next page, my lords. Your lordship would find out on the left, right-hand side, Form 1A.
Right.
I've underlined that portion, my lords.
Yes.
So on the strength of Form 1A, which is permissible as an exemption under entry 26A of the Finance Department laws, a person can buy goods for manufacture in his industry, tax-free. Then your lordship may come to the charging section, that's section 4. Okay.
Yes. Here.
I'm sorry for the inconvenience, my lord, sir.
No problem.
Charging section is section 4, my lords.
Yes. Incidence of taxation.
Incidence of taxation, my lords. Subject to the provisions of section 3B, 5, 6, 7, and 8, and with effect from such date as the state government may by notification in the Gazette appoint, being not earlier than 30 days from the date of the said notification, every dealer whose gross turnover during the year immediately preceding the date of commencement of Odisha Sales Tax Amendment Act 1991 exceeded the limit specified in subsection 7 shall be liable to pay tax under this act on sales and purchases effected after the date so notified. I need not take your lordship to the other thing. Here your lordship would appreciate that this charging provision is subject to section 3B, that is the purchase tax paid goods. My lord, you'll just those are goods liable for purchase tax. 5, my lord, is the calculation of the taxable turnover. 6, my lord, if your lordship would turn to 6, my lords, that is tax-free goods. Section 6, my lords.
Yes.
Tax-free goods, the state government may by notification subject to such conditions and exemptions, if any, exempt from tax the sale or purchase of any goods or class of goods, and likewise withdraw any such exemption. One of this being 26A, my lords, under the exercise of powers under section 6, my lords. Then section 7, I'm not really concerned with this because this is for a class of dealers and for deferment of sales tax, my lords. Again, an IPR benefit, my lords. So my humble contention, my lord, is the charging section itself, my lord, takes care of provisions of section 6 and 7. So exemption and to do away with the collection of tax, my lords, if I may put it as collection, is a part of the charging section, my lords. Here the question, my lord, is that what would be the exact meaning of the word levy, my lords? Because section 34, my lords, deals with subject to levy of tax. And whether levy, my lord, would be actual collection of tax, my lords. That will be my point number 1, my lords. Number 2, my lords, the legislature in 1980, my lord, this amendment came in 1978, subject to levy of tax. 26A came with effect on the 1st of August, 1980. So the legislature was very much aware of such a restriction in Form 34, so far as purchases of these IPR exempted units are concerned, my lords. And consciously, the legislature has made Form 1A, and it has not restricted them for their purchases from registered dealers who have purchased goods under the strength of Form 34. Lords. That will be my second submission, Lords. Then this particular aspect, my lord, was before your lordship, my lord. Your lordship may. Before your lordship's court, my lord, which was also noted by the learned tribunal, my lords, in State of Orissa versus Sahu Traders. Now, in State of Orissa versus Sahu Traders, my lord, they hold that the question, my lord, is at page 1.239, my lords. Whether on the facts, your lordship, what?
Yes.
Whether on the facts and circumstances of the case, when the opponent has purchased goods free of tax on furnishing declaration in Form 34 to resell in such a manner that tax is leviable on it, whether on its sale to other tax-free, it violated the provisions of its own declaration and also liable to pay tax as per second proviso to section 52A82 of the Odisha Sales Tax Act. And thereafter, the lordships have held that bearing in mind the aforesaid well-settled principles of interpretation, that's at page 1.242 at paragraph 4. Bearing in mind the aforesaid well-settled principles of interpretation of the statute and on exercising the facts and circumstances of the present case, we answer the questions posed by holding that the SSC violated and contravened the provisions of section 52A82 of the Act, and there has been a contravention of the declaration given by him. The question is answered in favor of the revenue and against the SSC. My humble submission before your lordship, my lord, is that their lordships have not analyzed the word levy, my lords. Their lordships have taken as if levy is collection, my lords. I'll only take, my lords, quickly to 3 Supreme Court decisions, my lords. Am I with your lordship?
Yeah.
The first one is PK re-rolling mills, my lords.
Yes.
If your lordship would kindly take the facts, my lord, at paragraph 2. It is in a way identical to the present case, my lords. May I just place it, my lords?
Yes.
The appellant is a company registered under the Companies Act having its registered office at Kozhikode. It is a registered dealer under the Kerala General Sales Tax Act 1963. It carried on business of steel re-rolling mills at Nalalam, Kozhikode. The raw material used by the appellant in the production of bars and rods is steel ingots, which the appellant either manufactures or purchases from other manufacturers from within or outside the state. Purchase of steel ingots effected by the appellant within the state are from manufacturing units, which are exempt from payment of sales tax on the sale of such ingots by virtue of an exemption notification issued under Section 10 of the State Act. For the assessment year 1994-95, appellant submitted a return of turnover and was assessed to tax, declaring the taxable turnover at nil by an order dated 15/1/1998 by the assessing officer. In respect of the assessment year 95-96 also, the appellant's assessment was completed determining the taxable turnover at rupees so and so by an order dated 15/1/1998. While this was so, the appellant received a show cause notice dated so and so for the assessment year 1994-95 and another notice dated 12/1/2000 on the same date for the assessment year 1996-97 to 1999-2000. In the first show cause notice relating to the assessment year 1994-95, the assessing officer stated that the appellant has purchased ingots from dealers within the state of Odisha who were exempt from payment of tax and consumed the same in the manufacture of bars and rods during the year 94-95. The notice further stated that the ingots purchased were goods liable to tax under the State Act, and since the supply of such ingots did not suffer any tax at the time of sale due to the exemption notification under Section 10(1) of the State Act, purchase turnover of the ingots during the year and consumed in the manufacture by the appellant attracted liability to tax under Section 5A of the State Act. The notice alleged that the purchase turnover of the ingots had escaped assessment under Section 5A of the State Act and accordingly proposed to determine the turnover liable to tax and assess the same at 4%. It was stated that on request of the appellant, a hearing would be given to the appellant before completing the assessment as proposed. Then the lordship may come to paragraph 5 notes. Aggrieved by the above order, because this matter was challenged before the Honorable Single Judge, the Honorable Single Judge relegated the matter to the statutory authorities. The matter was carried in appeal before the division bench, my lords. And I'll just place paragraph 5, my lords. Aggrieved by the above order of the learned single judge, because paragraph 4 is single judge, my lord. Paragraph 5 is the division bench. single judge, the appellant preferred two separate writ appeals. The division bench dismissed the writ appeals by common order and held that the learned single judge was in error in directing the appellant to avail the remedies provided under the State Act. The division bench, however, rejected the main contention of the appellant that in view of the provisions of Article 286(3) of the Constitution of India, read with Section 15 of the Central Sales Tax Act, it was permissible to levy purchase tax under Section 5A of the State Act. In support of this contention, it was submitted by the counsel for the appellant that iron ingots being declared goods could be subjected to tax at 5%, subject to tax under Section 5, read with the second schedule of the State Act in the hands of the seller only. That the declared goods, like the one involved in the present case, could be subjected to levy only at one point, and that point having been had been specified by the statute as being the first sale. The goods could not be subjected to purchase tax in the hands of the purchaser under Section 5A of the State Act. The division bench of the High Court, relying on the judgment of this court, rejected these contentions and held that the expression levy includes collection of tax as well and not mere imposition. It was held that in absence, I need not place the other fact. Your Lordship may straightway come to paragraph 22 minutes.
They make the distinction between levy and collection.
Your Lordship may straightway come to paragraph 20.
Actually, 25 is
important. That's 22 is the discussion about impact of exemption on liability of tax, where they have discussed about the liabilities, and 25 is distinction between levy and collection.
Yes.
That is important. The second aspect of the argument is that in absence of collection means an absence of levy or liability. This question has already been examined in certain earlier cases, and this court has consistently maintained a distinction between levy and collection. In National Tobacco case Supra, the court was faced with certain questions relating to the refund of excise duty on manufacture of cigarettes. In this context, the court examined the scope of the term levy and made the following observations. The term levy appears to us to be wider in its import than the term assessment. It may include both imposition of a tax as well as assessment. The term imposition is generally used for the levy of a tax or duty by legislative provisions indicating the subject matter of tax and the rate at which it has to be taxed. The term assessment, on the other hand, is generally used in this country for the actual procedure adopted in fixing the liability to pay a tax on account of particular goods or property or whatever may be the object of the tax in a particular case and determining its amount. The division bench appears to have equated levy with an assessment as well as with collection of tax when it held that when the payment of tax is enforced, there is a levy. We think that although the connotation of the term levy seems wider than assessment, and it includes, yet it does not seem to us to extend to collection. Then they refer to Article 265 minutes. Article 265 of the Constitution makes a distinction between levy and collection. Because your Lordship knows that Article 265 says that taxes not to be imposed save by authority of law. Then they say no tax shall be levied or collected. So they consciously use two terms, my Lord. The court made it clear that levy and collection are not synonymous and that collection of tax is not a necessary facet of levy. Then I need not go to this Article 265 collection, where they have said, may I please paragraph 26?
Yes.
They discuss about, and they have considered Wazir Sultan, my lords. They have considered ACC, my lord. Then paragraph 28, my lords.
Correct.
In the light of the above two cases, it is evident that collection and levy are distinct. And that collection is not an essential facet of levy. It is true that collection of a tax may sometimes be indicative of a lawful levy of tax, but in our opinion, it does not logically follow that absence of collection means an absence of liability. We are also of the opinion that reliance on Town Municipal Committee Supra by the division bench which involved an interpretation of continued to be levied and to be applied to the same purposes in Article 277 of the Constitution was misplaced. While that case did not hold that in the circumstances before them, levy was intended to include collection, in our opinion, the logic or ratio of that case cannot be extended so far as to say that even levy must include collection, and without such collection, no levy can be said to have been made. Then the conclusion part of it is there. Then the second judgment, my lord, is perfect synthetics, my lord. State of Punjab versus perfect synthetics. I'll just take away your lordships to paragraph 11, my lord. The lordship got me? State of Punjab versus?
Yes.
Paragraph 11. The question that arises for determination in this civil appeal is, what is the meaning of the word the purchase value of goods which has been subjected to tax under section 5(1)(a) of the in rule 29 Roman 12. Then your lordship straight away come to paragraph 13, my lords. We find no merit in the said argument of the department. In this connection, we have to construe the scheme of the 1948 Act. As stated above, section 4 is the charging section, where section 5(1)(a) indicates the point at which the levy takes place. The said 1948 Act refers to single point levy of tax on first sale. The notification dated 25/7/1990 specifically incorporates the provisions of Rule 9 of the 1991 rules, which requires that the unit holding exemption certificate to file the return under the Act and for assessment of an eligible unit in respect of such which exemption certificate has to be granted. The said notification read in entirety thus indicates the exemption given to the eligible unit under the Act is only qua the payability. The said exemption to the eligible unit is not in the matter of assessment. The reasons is obvious. The exemption is granted to the unit for 10 years or till the exemption entitlement gets exhausted, whichever is earlier. Therefore, under the notification, exemption is only qua payability and not in respect of assessment. That is the reason for incorporating Rule 9 of the notification dated so-and-so, which requires the eligible unit to file its return in the manner specified under the Act, to attach requisite documents, and for assessment in accordance with the provisions of the Act. Even with regard to payability, it may be noted that under the scheme of the 1948 Act, the calculated tax gets appropriated towards the scheme entitlement. Thus, this linkage into account, we are of the view that the words subjected to tax cannot be equated to the words having suffered tax modes. I need not let's take your lordship to the rest, my lords. Your lordship may come to then the lordship may come to the other one, that's Lloyd in electrical units. I'll just place paragraph 12. Sorry, paragraph 10, lords. Yes. Lloyd engineering. They here are considering the effect of a IPR exemption. We do not think it necessary to go into the various contentions raised by the parties in view of the undisputed factual position we have referred to above. The state government cannot speak in two voices. Once the cabinet takes a policy decision to extend its 2004 industrial policy in the matter of CST concession to the eligible units beyond 31/3/2009 up to 31/3/2013, and the notification dated 29/5/2009 accordingly, having been issued by the department concerned, namely Department of Industries, thereafter the Excise and Taxation Department cannot take a different stand. What is given by the right hand cannot be taken by the left hand. The government shall speak only in one voice. It has only one policy. The departments are to implement the government policy and not their own policy. Then this, once the Council of Ministers has taken a decision to extend the 2004 industrial policy and extend tax concession beyond 31/3/2009, mainly because the Excise and Taxation Department took some time to issue the notification. It cannot be held that the eligible units are not entitled to the concession till the department issued the notification. The rest of it may not be very relevant. So what I was trying to make out, my first humble submission would be that Form 34 itself and the condition attached speaks of a levy, not collection laws. And levy, my lord, cannot be equated to collection laws. And since the IPR exempted units, my lord, are also enjoying a benefit under the statute as per Section 6 and the consequent financial notifications of 26A, my lords, and they have given me a Form 1A, my lords, I have sold them at a zero rate, even though my declaration in Form 34 was that it will be subject to levy. So once this condition of subject to levy has been satisfied, collection is immaterial. What unfortunately this honorable court has held, they have equated levy and collection laws. They have said that since you have undertaken that it will be subject to levy and you have not collected tax and accepted a Form 1A, it is a violation of Form 34 and you are liable for taxation. So my humble contention would be this honorable court's judgment, my lord, even though relied upon by the sales tax.
Then you have to refer it to a larger bench then.
Sorry, my lord?
You have to refer it to a larger bench because it's a coordinate bench.
Yes. Yeah, it's a coordinate bench. Because I was only trying to impress upon your lordship. Your lordship may take a call on that, my lord. So I can't. So in view of the subsequent Supreme Court's judgment, my lord, and Wazir Sultan, ACC Cements, and the whole batch of cases, my lords, where they have said that levy and collection cannot be equated, my lords.
So we can say that the judgment holds no good in view of PK and Punjab.
My lords, and the other cases, my lord. And the second judgment, my lord, which that is perfect synthetics, if your lordship would say, take up. They have said
State of Punjab versus perfect synthetics.
Perfect synthetics.
Yeah, you've given us that.
My lords. There, their lordships have also taken into consideration, my lord, what will be the subject to tax. They have also discussed in paragraph 13, my lords. What will be the term subjected to tax and whether it can be equated as having suffered tax, my lords. Here it is subject to levy, not even tax, my lords. Language, as I've already placed as Form 34 before lordship, is that it will be sold in a way where it will be subject to levy under the Act. And once they say subject to levy under the Act, my lords, I'll also be making a submission before your lordship would be that the Act also includes Section 6, that Act also includes Section 7, my lords. So it can't be dehodes the exemptions enjoyed under Section 6, my lords.
Right.
And this benefit under Section 6, I've already placed Lloyd, my lord. It can't be defeated and a statutory benefit cannot be denied, my lord, to the IPR.
What is the point about this Orissa Additional Sales Tax Act?
Not that demand is not much, outside.
All right.
Because it is only half a percent.
One is the only question there.
Sorry, the main question would be whether there is any violation of Form 34 declaration if I sell it in to a unit who is enjoying IPR benefit under 1A. So, in fact, my humble contention will be the first one would be relevant.
Right.
The Form 34 which my learned senior showed, the relatable statutory provision is Section 5 to capital A, subclause 2A. And the language that is there in the form, that is also in the statute. It says that sales to a registered says, in this act, the expression taxable turnover means that part of a dealer's gross turnover during any period which remains after deducting therefrom A, his turnover during that period on to subclause I am 2I, sells to a registered dealer of goods specified in the purchasing dealer's certificate of registration for resale by him in Orissa in a manner that such resale shall be subject to levy of tax under this act.
Yes.
That my learned senior is placing that this is not collection and this is levy of tax. But exactly most of these arguments which my learned senior placed In fact, that has been, though the judgments has not been taken specifically noted down, but most of these arguments have been taken in that judgment, State of Orissa versus South Traders. In fact, your lordship,
No, Sahu Traders is a much earlier judgment.
most of these arguments that the state cannot speak in two voices and all, those have been dealt with in that judgment. That has been raised in that judgment and has been answered. And the question is identical. The question of law is identical to this State of Orissa.
But in view of the Supreme Court judgments, the holding in Sahu Traders may not be good law anymore. Because there are all the Supreme Court judgments, one is 2007, the other is 2008, the third is 2015. Sahu Traders may no longer be good law.
2007, my lord, it takes care of Somaya Organics, it takes care of Wazir Sultan, my lords, it takes care of lords, Pine Chemicals, it takes care of ACC Cements and other line of cases relating to levy and collection. So I had not individually placed those judgments because this judgment takes care of all the three other judgments.
Right.
And so far as Sahu Traders is concerned, it was decided in 22nd of December 1994. Much prior to that. And this question of the difference between levy and collection was never discussed. And the
Correct. Then we'd have to.
And your lordship, subject to what your lordships, and this fact, Lord, that this particular restriction was in 1998 and 1980, this 26A was inserted by the Finance Department. So my humble contention would be the legislature was aware of those restrictions, which were there in Form 34 minutes.
Right.
And the charging section itself takes care of Section 6 and 7 minutes.
Right.
And Section 5, which my learned friend has placed, is not a charging section.
Correct.
It's only a computation of liability, a computation of the taxable turnover.
Right.
It's not the charging section. So my humble contention, Lord, subject to what your lordship knows, that these will be more in the nature of ironing out the creases, my lord.
Right.
Instead of referring it to a larger bench.
Correct.
In view of the subsequent, but that will be my humble submission, subject to what falls.
No. That's
so
what
those
we don't need to refer to a larger.
Palpable evident creases may be ironed out by you.
All right. Orders reserved. You'll say the written note of arguments if you want to file it within 1 week. This provision, since we don't have that book, you may want to give that.
I'll give it. Because 26.
Oh, it is there. Okay, he's got it. All right.
There's 80 IPR minutes.
Right.
So 80 IPR in these books, my lord, was not there when those books.
No, he's found the book. He's found the book.
Form 34 is there in the new book.
Yes.
And also
No, all that is there. Only this 26A was not. Now it's there.
The court martial is kind enough to note his flag mark 26A.
Correct.
May I call on it?
Yes.
In view of those judgments, Lord, I don't.
No, we're not referring to a larger.
Item number 38.
Do you have to file a written note of argument?
Yes, within a week.
Item number 38.
Lordship, you say that these judgments may be taken care of and need not again enclose that in my written note.
No, right now.
I'll only refer to them.
Correct.
Much obliged, Lord.
Supplementary list for hearing item number 38.
Please, your lordship, I'm on the VC, Lord.
Yes.
Fine. Lord, if your lordship takes up page 16, annexed to 1 series.
Yes.
If your lordship sees 30th March 1988, the petitioner along with the others filed an application for settlement of fair equitable rent in respect of so-and-so plot in terms of the 1930 settlement ROR. This petition was filed in pursuance to a government notification enabling persons in whose name the lands were not settled, but they were in possession over the same, subject to inquiry, my lord. Now, if your lordship sees the operative portion of that order, that is page 22.
Yes.
22, if your lordships kindly see the last paragraph, it starts from as per.
Yes.
My lord. As per GO number 19327 dated 24/3/88, the powers of the OEA collectors for initiation suo motu proceedings for OEA license were withdrawn with effect from 24/3/88, basing on the application filed on 29/3/88. This case has been started on 30/3/88, and at that, the ACO Bodhapur, who was declared collector under the OEA Act, had no power to initiate the proceeding as per OEA lease. In view of the facts stated above, this case is not maintainable and hereby dropped. If your lordship kindly sees annexure A/4 is that notification which on the basis of which the order has been passed.
Yes.
Now, if your lordship sees I'll just place a few paragraphs. I am directed to invite reference to your letter on the subject cited above and to say that in this GO number 4610 dated 18th January 1977, the Tahsildars were given suo motu powers of settlement of land with the intermediaries and personal service holders without waiting for the petitions from them. In the meantime, more than 11 years have passed, and it is presumed that settlement of land might have been done in all the genuine cases by now. It is noticed that some of the Tahsildars have abused the suo motu power and granted leases in favor of intermediaries and personal service holders who otherwise are not eligible for such settlement. Government therefore have been pleased to withdraw the suo motu powers of the Tahsildars. Accordingly, this department GO number 4610 by R dated 18/1/77 is hereby rescinded with effect from the date of the issue of this instruction. Now, if your lordship sees, I have filed a document taking leave of this honorable court by order dated 9th of February 2022. So lordships have the order dated 9th of February 2022.
Yes.
But there my learned senior was appearing for your lordships, and there it was stated that the impugn order of the Tahsildar dated 12 December 1990 was based on the GO dated 14th May 1976, which indicated the last date of settlement, Khas Dakhal land under the OEL Act as 31st December 1976. He, however, points out that the subsequent GOs dated 24th March 1988, dated 24th June 1988, the petitioner's application would not be time barred. He undertakes to file a copy thereof with an advance copy to Mr. Mahanti, learned AG, within a week. If your lordship sees that flag T, that document has been filed with your lordship, flag T.
Yes.
Yes, your lordship. Now, my lord, this notification, government order, in fact, 24/6/88 is in pursuance to 24/3/88, which is on the basis of which my application was dropped. Placing the first paragraph your lordship sees, in enclosing a copy of the letter number 19327 by R, dated 24/3/88 of the Government of Orissa Revenue Department, addressed to the Land Reforms Commissioner, Orissa Cutter, and letter number 5288 so and so dated 24/5/88 issued by.
It says it should be treated as pending cases.
Yes, my lord. And till the 31st of July 88, any application which is pending is to be disposed of.
Okay.
So therefore, it is not time barred, my lord. So therefore, it has to go back.
All right. Yes. What do you say?
By virtue of this notification, the only remedy is to get back. The matter will go back to the. That I was verifying this notification which my learned friend has filed.
You say pursuant to the order passed by this court on 20th February 2022. Counsel to the petitioners have placed on record copies of the notifications dated 24th March 1988 and the subsequent notification dated
24
June 1988 by the Consolidation Branch of the Board of Revenue, Orissa. Good stop. The last mentioned notification clearly states that although the power of the Tahsildars to start suo motu cases for settlement of land was withdrawn by the government by the letter dated 24th February 1988, it has been clarified by the Land Reforms Branch that the suo motu cases pending and the Bay Bandobasta Hatas should be treated as pending cases, and action should be taken to settle such cases by the fixed time, that is end of July 1988. Paragraph: in the present case, the order dated 1st September 2001, the order dated
The 12th of December 1990.
Yeah, 12th December 1990, passed by the Tahsildar in OBA case number 21 of 2008. 2008 or 88?
21 of 88.
21 of 88
21 of 88.
was dropped by the Tahsildar on the ground that the suo motu powers had been taken away by the first mentioned notification dated 24th March 88. So in view of the subsequent clarification issued on 24th June 88, the impugned order dated 12th December 1990 of the Tahsildar is set aside, and OBA case number 21 of 1988 is restored to the file of the Tahsildar Krishna Nagar for a fresh decision in accordance with law. Bodhapur or Krishna Nagar? What is it?
Kishore Nagar.
Kishore Nagar, is it? No, just see that.
The order states Kishan Nagar.
Kishan Nagar.
All this, both Kishore Nagar, Kishan, anything can.
All right. The matter will now be listed before the Tahsildar Krishna Nagar on 4th May 2022 for directions. All right. The petition is disposed of in the above terms.
Obligement.
The petitioner may be directed to produce the order before.
A copy of the downloaded copy of this order be produced on that date before the Tahsildar
by the petitioner.
Right.
Supplemental list, item number 39. Supplemental list, item number 39.
None appears. This is not also.
Supplemental list, item number 40.
My lord, the monument of 3rd century AD has been declared by the government of India, Annexure 3, page 22. But I pray, in spite of the declaration, no conservation work is being undertaken. Annexure 4 is, my lord, the competent authority. Superintending Archaeologist, OP number 3, and the Director General. Lordship may direct both the parties. Before the rainy season, my lord, it is in climatic ruination, the monument. So the application addressed by the trustee to the managing OP number 3, my lord, Superintending Archaeologist, he may be directed to conclude the conservation work and other infrastructural facilities by certain period before the ensuing, my lord, rainy season. Annexure 3 is the notification, my lord, page 22. The monument is declared.
Pursuant to my lord's direction, my lord, a report has been submitted at flag B by the superintendent of archaeological. Flag B, the report has been submitted before this court, my lord.
Certain demarcation work is over, it is reported, but demarcation within the, my lord, state government Tahsildar and local Tahsildar and technical staff of superintending archaeologists, they have concluded the demarcation proceeding. But the other, my lord, the admissible works to be undertaken under the National Conservation Policy in order to protect the monument from climatic ruination, some activities are required. So that is to be looked into by the OP number 3 With also approval of from the OP number 2. So that is my simple prayer, because it is the monument, all the citizens, it are sacred duty to protect because after the great endeavor, it has been declared as the monument of historical importance. Annexure 3, page 22.
My humble submission, already step has been taken. Your Lordship may kindly see the report under annexure at flag D, which has been produced before your Lordship.
Demarcation work is over.
That has been specifically stipulated. Your Lordship may kindly,
Because
at flag D, the report is there. Your Lordship may kindly see new construction at page
half
6.
broken condition. Crown is not
already
there.
Process has been started. So far as the difficulty we are faced for the demarcation to construct.
No, what has happened? This letter was written in 12th April 2019, 3 years ago.
19 years.
No, this is written. This is dated 12th April 2019.
Yes, ma'am.
What has happened 3 years later? Where are we now?
Because
has this demarcation been completed? This Tahsildar Nischinta Koili was supposed to complete the demarcation.
That's why exactly your Lordship, by order dated oral prayer of the petitioner, collector has also be added a party. Your Lordship, we specifically given annexures in our counter that the demarcation could not be possible carried out due to absence of Tahsildar and as well as the RI. In the meantime, I had taken instruction that in January,
after great persuasion,
already demarcation has been made for the construction of a wall.
You say the court has perused the report dated 12th April 2019 of the superintending archaeologist of the Archaeological Survey of India, (ASI), Bhubaneswar Circle. In relation to the steps taken for preserving the Ananteshwara Mahadev temple in Lendura Bhagwanpur, district Cuttack, which has by notification dated 2nd April 2014 of the ASI been declared to be an ancient monument of national importance. The said letter inter alia states that there is a sketch plan drawing which has to be physically demarcated on the ground by the state authorities. And the matter is pending before the Tahsildar Nischinta Koili, Cuttack. It also points out that at present, the centrally protected monument is surrounded by many modern structures falling under the prohibited area in the name of worship, open quotation, in the name of worship, which contravenes the AMASAR Act, which are to be removed in due course, unquote. The court directs the collector Cuttack to file an affidavit on both the above aspects, namely the completion of physical demarcation as well as removal of structures that contravene the AMASAR Act that are surrounding the centrally protected monument. The affidavit will be filed not later than 20th June 2022 with an advance copy to counsel for the parties. This on 4th July 2022.
We have the petition be served so that
To be served on everyone.